Good afternoon. Welcome to the Appellate Division First Department. As I call the calendar today, please ask for the time that you actually need. Almost 8.5 hours of argument time has been requested, and we will not be able to accommodate that. We have read your papers and are familiar with your arguments. For those of you here for the first time, the light on the lectern, when the white light on the lectern goes off, you will have 2 minutes. Or if you've asked for less than 2 minutes, it will go on immediately. When I call your case, rise and ask and let me know who you represent and how much time you are requesting. People v. Hurtado. Please. 4 and 1 and 3. Brady v. New York County District Attorney. Mr. Brady, usually when there's no opponent, we give 3 minutes, so I'll give you 3 minutes. Thank you. Weir versus Weir. Five and 2 and 5. Robinson v. Duza. I'm sorry? Okay. How much time do you want? I'll give you 2 and 2 and 4. Lipinski v. MIP 1 Wall Street. 4 and 2 and 4. Thank you. People of Germaine Vanderhorst. 5 and 2 and 5. Violia Energy North America v. OnWave. 5 and 2 and 5. Torres v. Ioino. You appear not to have an opponent. Do you wish to address the court? I'll give you 3 minutes. Very well. People v. David Havid Dore. 3 and 2 and 3. Board of Managers v. 56th and Park. 5 and 2 and 4. People of the State of New York v. National Rifle Association. 5 and 2 and 5. People v. Jason Perez. 3 and 1 and 3. O'Sullivan v. American Golf Corporation. 3 and 1 and 3 and 2. That is 3 and 1, 3 and 2. You're welcome. Valencia v. Saul Goldman Investments. 5 and 2, 3, 3, 2, 2. Thank you. Gonzalez Taveras v. City of New York. Submitted. Suazo v. 501 Madison, Sutton. 4 and 2 and 3 and 3. Arabalo v. Century, I believe is submitted. People v. Christopher Messias. Could be 5 and 2 and 5. Eastern Effects v. 3911 Lemon is submitted. First case up is People versus George Hurtado. Please.
May it please the court, Jackson Samples for the appellant, Mr. George Hurtado. Mr. Hurtado's prison sentence for larceny should be reduced to a term of 3 to 6 years. And today I want to focus on two main mitigating factors in his case, his remorse and his struggles with drug addiction.
Now, he does have 8 felony, or this is his 8th felony conviction, is it not?
Correct, Your Honor.
And he also has some other offenses out of state, is that correct?
Yes, Your Honor.
Okay.
And, about his criminal history, he was...
Well, in the last 31 years, he's accumulated over 15 separate convictions in New York City, including second-degree bail jumping, fifth-degree criminal sale of controlled substance, and a raft of grand larceny and petty larceny convictions. Am I right?
Yes, Your Honor. And about his criminal history, he was sentenced as a predicate, so this was reflected in his sentencing range. And it's also noteworthy that none of his prior convictions were for violent crimes, and these included, like you said, Your Honor, a drug conviction and a theft conviction. And so these were likely affected by his struggles with drug addiction as well. And with respect to his drug addiction, this began when Mr. Hurtado was a young teenager. He was just 14. And in this case, Mr. Hurtado admitted to committing his offenses so that he could buy drugs and manage the debilitating withdrawal symptoms that come from his addiction. At the time of his offense, in fact, his struggles with drug addiction were at their peak. We know that right around this time, Mr. Hurtado was hospitalized twice after overdosing, and he received detox treatment. And so this shows that the main contributor to Mr. Hurtado's offense was his compulsion to use drugs, and this was really a symptom of his chronic disease.
Didn't the judge take all of these issues into consideration in coming, in working out the plea? These were all considered by the court now?
Yeah, this information was before the sentencing court, Your Honor, but this court should exercise its discretion to give the mitigation in this case more weight and reduce Mr. Hurtado's sentence accordingly. I also would like to talk about Mr. Hurtado's sincerely felt remorse in this case. So during his pre-sentence interview, he told the probation department, quote, "I'm very sorry for what I did, and I know it was wrong." He acknowledged that he stole property and explained that his drug addiction contributed to his offense. In his own words, he understands his addiction makes him, quote, "not the person he's supposed to be." And the sentencing court said on the record that not only was Mr. Hurtado pleading to the top count, but he expressed remorse to the probation department. And so
That's the lowest sentence offered, correct?
yes, Your Honor. And so, yeah, he was sentenced to 3.5 to 7 years.
But his exposure was 7.5 to 15?
Correct, Your Honor. And so I think his reflective statements of remorse show he's unlikely to repeat his offense, and it also bolsters his commitment to becoming sober. So we know that he desperately wants to do this. He said this before the probation department, and he wants to do this with the help of his faith, his family, his community, and addiction services, which Mr. Hurtado has previously received from St. John's University. And so this shows that Mr. Hurtado is seeking to overcome his addiction. He's willing to ask others for help and knows of places he can go for help as well. I would like to also add that Mr. Hurtado has family support. He's the father of 5 children and has a grandson, and he's the primary caretaker for his mother ever since his father passed away from COVID-19. And so not only will his family be able to support him in reintegrating to the community upon his earlier release, but he will be able to return to his role as a caretaker for his family.
Didn't he have that family support before this last crime?
He did, Your Honor, and I think his family, particularly given his statements of remorse and his dedication to seeking long-term treatment in the future, they understand that this is something that he remains committed to, and he will be seeking in full force upon his earlier release. He will also have the support of the parole folks and as well our office's reentry services.
Thank you, Counsel.
Thank you.
Good afternoon, Your Honors. May it please the court, Jennifer Mitchell for the people. Defendant's bargain for sentence was lenient and should not be disturbed on appeal. For stealing property valued at over $50,000, defendant was initially charged with 4 counts in his indictment. If he had gone to trial and been convicted of just the top count of second-degree grand larceny as a second felony offender, he faced a maximum sentence of 7.5 to 15 years. In this case, he received a plea deal where he received a sentence of 3.5 to 7 years.
Pretty close to the minimum.
Yes, Your Honor, exactly, very close to the minimum. As Your Honors have already pointed out, he does have an extensive criminal history as well, and the sentencing judge had already fully considered all of the purported mitigating factors that defendant has put forward. If this court has no questions, then the people ask that you affirm. Thank you.
Thank you, counsel.
I will be brief, Your Honors. The first point about his criminal history, I just want to note that other than one case, his most recent case before that was from 2016, so a lot of this is old and behind him. And I also just wanted to add that with a reduced sentence, Mr. Hurtado will be able to receive drug treatment while he's incarcerated in docks and be able to complete that before his release.
He can't get that with the present sentence?
He can, Your Honor, but I'm saying he will be able to complete them because docks offers
Within
a
the
few months
shorter
of it.
time frame.
Yes, with the shorter time, he will be able to complete that. And we ask for the modest sentence reduction to make his sentence 3 to 6 years.
Thank you, counsel.
Thank you.
Thank you both. Brady v. New York County District Attorney. Justice Chan is recused on this case. Thank you. Please.
Thank you, Your Honor. For over a decade, the November 23rd,
Mr. Brady, bring the microphone a little closer.
for over a decade, the filing injunction that Judge Chan imposed on November 23rd, 2015, sua sponte, has prevented me from seeking declaratory relief as to which decision in this court governs, the February 11th or decision or the lower court July 15th, 2014 decision. The fact that the lower court completely misrepresented what this court adjudicated can very easily be simply proven by comparing what the court actually said in its February 11th decision against what Judge Cornrich said was adjudicated in her July 15th, 2014 Supreme Court decision. So I ask the court, if you go to page 32 of the record and you see paragraph 17, you will see the governing language. And if you go to paragraph 18, you will see what the court affirmed in its February 11th decision. And then if you go to the next paragraph, you will see the way it was rewritten completely by Judge Cornrich to void what the higher court decision said on its face. So if you look at the seventh paragraph as written, it says the 12th floor roof unit shall have, in addition to the utilization, the right to construct or extend structures on the roof or above the same to the extent from time to time permitted under applicable law. The Appellate Division, First Department, in its February 11th decision ended with the same thing pursuant to paragraph 7. Plaintiffs have a right to construct or extend structures upon the roof or above the same to the extent that may from time to time be permitted under applicable law, unanimously affirmed without cause. And then the rewriting says, it has already been adjudicated that while the owners of the unit may have a right to construct additional structures on the roof, that does not entitle them to use any floor area in doing so. Nothing herein shall be construed as holding that the plaintiff has a right to use all or any part of the TDRs in connection with such construction or extension, holding that the offering plan reserves for plaintiffs the right to construct or extend structures on the roof that may be built without the use of the building's development rights. That is completely a lower court rewriting to void what this court said in its higher court decision. Furthermore, I do appreciate that the Manhattan District Attorney in the city of New York did not come forward to oppose this motion because it's so clear. And the new evidence I have to mention, it pertains to a number of you. Judge Shulman, and you were presented in the Hakel panel. Part of
Red
that.
light is on, sir. Thank you very much.
Okay, and you were also
time
on
to
the
step
other
down, sir.
panel, sir.
Thank you.
So you know what it says, Judge Moulton.
Mr. Brady, the oral argument is over. Thank you.
Mr. Moulton, the last time you didn't give me time to finish. You wound up making 15 mistakes that are in my re-argument motion. 15.
Thank you, Mr. Brady. Weir v. Weir. Justice Kapnick is recused on this and will be joined shortly. Wait for Judge Chan to come back. Thank you. Please.
Good afternoon, Your Honors, and may it please the Court, Aaron Zucker of Morrow Lilling, the party, on behalf of Appellant. I'm going to start with the room and board credit issue. The law says that where parties have reached an agreement regarding the ancillary issues in a divorce, and they provide that the party will pay for child support, and then separately they will pay for the college and educational expenses. No
You're
room.
seeking to have us vacate the room and board credit.
Correct, Your Honor. Unless there are any other questions on that one, I'll move on to the downward modification. The court granted a downward modification of the party's basic child support agreement based exclusively on the fact that one of the children has since become emancipated. The party's agreement says that the obligation to pay child support will last until the emancipation of both children. So in doing so, the court has rewritten the party's agreement to which they bargained for. So basically what the court did here was improper because it rewrote the party's stipulation of settlement.
But does that argument make sense, that you have to wait for both children to reach majority?
Yes, Your Honor, because that's what they agreed to. This was an agreement regarding the payment of child support. It was unallocated between the two children. It said that child support will be paid until the emancipation of, for both children, Your Honor. It doesn't distinguish between one child being emancipated and that entitling the husband to some type of reduction because only one child is now non-emancipated.
Now, does both children, it does appear somewhere in the judgment of divorce.
Page 162, Your Honor.
What's that?
Page 162 of the
I'm
record.
looking at it, okay. Because, of course, the other side said that it doesn't appear in the judgment of divorce, but there it is on record 162, right?
162, Your Honor.
Read as when each child reaches age 21, when they're both 21, they can then, not that they're both 21 together, or they have to be emancipated, considered emancipated at the same time?
I don't think so, Your Honor. I think it's just upon the emancipation of when, it doesn't have to be at the same time, when the latter of the two, if it's done separately, then yes, it would be determined based on the latter's emancipation.
Do you
time.
agree that emancipation means the age of 21?
There may be some litigation going on in terms of the underlying regarding that, but for purposes of this brief, we've assumed for all arguments that the one child has been emancipated and that our contention is it's irrelevant because what the stipulation of settlement says is that both children have to be emancipated in order for the basic child support obligation to cease.
Counsel, has the financial hearing gone forward yet? Or when are you scheduled to appear?
That I'm not sure. I'm not appearing in that, so I'm sorry, Your Honor. I don't know the date of that.
Well, it pertains to your client's request for attorney's fees, because that would be a context in which he could seek them. I mean, that's what you want us to do, right?
It could be, yes, Your Honor. But we still believe that they're entitled to attorney's fees based on the motion practice that our client has had to engage in based on the other side's, I guess we've called it vexatious litigation in inappropriate positions taken. The judgment of divorce required the husband to do certain things in order to transfer title to a property to the wife. There were court orders ordering him to do it. He chose not to. It required the wife to make enforcement motions, which then in turn led to a re-argument motion, which then in turn led to an appeal before this court from the improper grant of the re-argument
Your
motion.
opponent says, or points out that your client's made 12 motions since August 2020, but your argument would be that's because we're forcing compliance.
Yes, Your Honor, and also I don't think that the number of motions that our client made negates what my adversary has done and how what my adversary has done has obligated our client to make these enforcement motions. So unless Your Honors have any other questions, we ask that the
Thank you.
order be reversed. Thanks.
You have time to rebuttal as well.
Good afternoon. May it please this court, Annette Hesapidis appearing for the plaintiff. I'd like to start with the downward modification argument. There is no agreement and there is no statement in the judgment that the support shall continue until both are emancipated. Page 162 of the record, Your Honor, is the findings of fact.
It's what?
Is the findings of fact, not the judgment. The findings of fact were drafted by defense counsel. And the same page at 162, I would also point out that on the same page it also says, you're reading from paragraph 22, Your Honor, that says it shall continue until the emancipation of both children. A few lines down in paragraph 23, it discusses the formula for support and said, such payment should be made on the first day of each month until the emancipation of the children. Yeah. So there's poor and ambiguous wording, but there was never an executed agreement, which is what counsel refers to at page 1 of their reply brief. They argue that there's a fully executed agreement that includes this. There is no such thing. They've argued that it's in the judgment. It's not in the judgment. There's an on-the-record stipulation that made no reference to emancipation. Page 162 of the record.
Certainly, you have the commonsensical argument that child support should be based on how many children are getting, are embraced within the support. And
Yes.
if one child is emancipated, which is what happened here, then you have one child left. That's your
Yes.
argument.
Yes, and also page 166, which is also the findings of fact, says that child support shall be exclusively governed by the open court stipulation, which did not include any proviso about emancipation. So the findings of fact, the judgment, and the open court stipulation do not support the claim that child support must continue past emancipation. The daughter is now 24 years old.
Getting back to the younger daughter.
Yes.
The Supreme Court gave a credit for
Room and board.
for the tuition and room and board, right?
Not tuition, just room and board.
Room and board.
Right, so
But isn't that an independent obligation? Didn't the judgment talk about those optional, not quite optional payments besides tuition that
Well,
go in the mix?
what the judgment said was that my client was responsible for 93% of tuition, room, and board.
Right.
But there was no mention of a RORS credit, really, is what we're talking about here, right? So at this point, they're asking that support of $125,000 a year be continued, in addition to my client paying a total of,
That's separate from the basic
$23,000 a year for room and board, while the child lives in child lives in California 9.5 months a year. They're asking that the same support for two children, $125,000 a year, be continued, in addition to my client paying $23,000 plus a year for the room and board. The court correctly determined that my client was entitled to a downward modification of the $125,000 because there was no evidence that the child's needs were not being met. In fact, the amount is excessive. This is not a situation where if support was reduced, the defendant would have to change her living accommodations. The record's clear. She has a greater net worth than my client. She's got a net worth of $4.3 million and zero debt, and my client has a net worth of $2.8 million and $2.4 million in debt.
Is that before trial court at the moment, that disparity? Because, of course, the other side used words like astronomical, massive, in terms of the financial disparity, and that it favored your client.
Well, yes, but the net worth statements don't bear that out. The net worth statements of the parties from March of 2024 show the respective debt to net worth of the parties. With respect to...
Do you know when the financial hearing is going to go forward on this?
Yes, it's scheduled for May 21st. It was originally supposed to start yesterday, but it was adjourned due to the unavailability of certain non-parties. So it's starting from May 21st. There are 7 dates scheduled into June before the special referee. And frankly, one of the reasons we're in this mess, frankly, with respect to all of these fees on all of these motions, is because the defendant never put in a form the special referee information statement. The court, in its decision at page 40, pointed out that it had reviewed the docket, and there was no indication that as of January 2024, the appellant had asked for a special referee. With respect to the fees,
The attorney's fee.
yes, the attorney's
by the
fees,
ex-wife,
right?
yeah.
The court did not deny the request for fees under silence. There are numerous orders. There's an amended order of reference holding that a fee hearing should be held, as I've just told you, with respect to those
You'd have no
dates.
objection to a fee hearing go forward. You might contest that she's not the moneyed spouse, or she's not the unmoneyed,
We're simply asking that the claim for fees raised by this motion, Motion 25, be resolved in the fee hearing, which is about to proceed. That the record's insufficient here for the court to address that.
Thank you, counsel.
Thank you.
Please.
I just want to briefly address the issue of the downward modification. And this was an agreement that the parties reached a long time ago. They contemplated all of the situations, including the children going to college, including the children one day becoming emancipated. They reached this agreement a long time ago. Just because maybe the terms aren't now so favorable, or maybe with the benefit of hindsight, you could have negotiated better terms, doesn't mean that just due to displeasure with what you agreed to a long time ago, that in and of itself is not a basis for a downward modification. Thank you, Your Honors.
Thank you, counsel. Thank you both. Robinson v. D'Souza. Please.
May it please the court, my name is Vanessa Corchia from Armienti, DeBellis, and Roden. I represent the defendants, MTA, Metro North, and Mr. Hermanowski in this matter. Our position is that we have a he said, she said motor vehicle accident, not capable of resolution on a summary judgment motion based on conflicting affidavits.
Well, it's not quite. He said, she
Excuse me,
said.
Your Honor.
It's two he said.
Okay,
But also,
I agree.
You're right. There are dueling affidavits.
Davids,
And that, in your view, creates a triable issue of fact, and they should
Correct.
not have granted summary judgment on liability.
correct.
But culpability, you're not really disputing.
Culpability or the accident.
Isn't the plaintiff was in the plaintiff was in the back, a passenger.
Of the co-defendant's vehicle.
She didn't contribute to the accident.
I can't say she contributed, but I can say her testimony was at odds. Her affidavit that she presented on her motion was at odds with testimony that she gave in a pre-suit statutory hearing. This motion was made very quickly after suit commenced. At that point, the only testimony was from the statutory hearing. So you had her testimony, and then you had 2 affidavits of the drivers. And I think it's important to note that her affidavit conflicts with her own testimony with regard to the movement of the vehicle, because she says that she needed to go purchase some supplies, she needed to run across the street, and she testified, and he was about to stop. That actually supports what we said, that the other vehicle quickly and abruptly came into our lane.
Thank you,
So
counsel.
that's,
Our traffic light is on now. You have time to
thank you.
rebuttal.
Okay.
Please.
May it please the court, Joshua Block on behalf of the plaintiff. I would like to begin with the same concession that we included in our brief, which is that the innocent passenger, the fact that she was an innocent passenger does not get her summary judgment on the issue of liability. It does, however, get her summary judgment on the issue of
Culpable conduct.
yes, Your Honor, because there's no triable issue of fact that there was a collision and that she was the back seat. There's no evidence that she in any way contributed to it. The most that they can say is that her hand was on the door, which I don't know how that causes an accident.
And are you representing that the conflicting testimony that your friend mentioned does not paint any culpability on your client's part?
Correct, Your Honor. I would actually go, though, a step further, and in our brief, we've argued that we are still entitled to summary judgment on the issue of liability outside of the fact the innocent passenger.
Isn't that contradicted by the second decision? We're here on appeal on the July 5th decision, but there's also that July 1st decision.
Yeah, so the court
I mean,
can...
it seems like there's some kind of conflict between those two decisions, and that maybe the natural result is to say there is an issue of tribal fact concerning the party's negligence,
Yeah, so
not your client's.
So the court did come to conflicting decisions. We couldn't appeal the other decision. We were not aggrieved by it. Summary judgment was denied as to the defendant, not this defendant, the other defendant. And so therefore, we were not aggrieved by it. But that said, this court's not bound by either decision of the Supreme Court. The law of the case doctrine does not apply to this court. It didn't even apply as to this. The court could have switched it. Because otherwise it's just going to go round and around and around, right? If it's
Isn't that what a trial is for?
if outside of the evidence, yes, but here the evidence only shows that their driver is liable.
How? With the photograph showing no damage to the rear of the vehicle?
So it's uncontested that the two vehicles collided. There's two different stories as
The issue, counsel, is whether it was a side swipe or whether it was a rear-end collision. To the extent that the parties want to go to trial, it's up to them, correct?
I mean, you mean, I don't understand your question. You mean go to trial versus settle, or because, right?
Well, sure, but here, you know, if it's a rear-end collision, normally we see evidence that backs that up. Here, what we see is nothing in the photograph, at least, that shows any damage to the rear of the vehicle, but rather damage to the side of the vehicle. So under those circumstances, notwithstanding the photograph, to the extent that there's conflicting testimony, how is an appellate bench in a position to determine what the true facts are?
So I think that what you're asking is who is more at fault? Because the
No, I'm saying, don't we need a trial here?
I don't, because I don't think that the photographs prove that this defendant is not liable, because based on his own affidavit, what he says is, I looked in the mirror, he doesn't say what he saw, and I pulled forward. And then within 3 feet of pulling forward, that's when the accident occurs. So by his own affidavit, what he has essentially said is, I either did not see this other car that's about to turn in, because again, 3 feet is very quick, or that this other car had already started. But no matter what, no matter how you look at their affidavit, ignoring speculation, it still supports our contention that the plaintiff should get summary judgment on the issue of liability. I see I'm out of time if there's no more questions.
Thank you, Counsel.
Your Honors, I think it is very clear from there's 3 orders before you where the court plainly says there are divergent stories as to how this happened. I'm not sure why then summary judgment was granted in plaintiff's favor against the driver and owner I represent, the MTA, because it appears to be described as a side swipe, and the question is who went into whose lane? And I think it necessarily is a question of fact And I think the court
I
below
think
even acknowledges that.
Counsel, I think it's not just the decisions, the affidavits seem to, just looking at the affidavits of the different parties seems
Right.
to raise some issues here, right?
They do, and that's why I believe we need to have a trial as to liability. Thank you, Your Honors.
Thank you, counsel. Thank you both. Lipinski v. MIP 1 Wall Street.
May it please the court, David Scher for the appellant. Our client, Mr. Lipinski, should have been afforded the protections of the labor law. And I'm just going to go straight to the two decisions cited by the lower court, and only two that are post-Pratt's, and therefore the only two that matter, I think we can agree. Since 2023, of course, we have a rule about whether work like this is covered or not. And there are only two cases that are relied upon, and they're easily distinguishable, and they illuminate our position well. One is Toro, this court's decision from 2011. And yes, the plaintiff in Toro was a sanitation truck driver who was removing debris, like our client. The similarities end there. What happened in Toro...
They ended because the debris removal was concomitant with the construction work, with the supervisor being there washing everything from the upper floors as it was being carting out debris, correct?
Because
Whereas in
the
Toro,
demolition...
the work was done months before.
Correct. The demolition phase was done, and this worker was simply going to retrieve debris. There was no ongoing construction. This court could have held in Toro if it wanted to. It could have said removal of debris is simply not covered. It could have said, if it wanted to, that sanitation workers are not covered. It didn't. What this court instead held is that that case wasn't covered because, quote, the plaintiff was not performing tasks ongoing and contemporaneous with the greater project, and the work he was performing was a separate activity easily distinguishable from the construction project. In our case, every one of those factors is the exact opposite. Mr. Lipinski's work was ongoing and contemporaneous with the greater project. His work was not a separate activity easily distinguishable. On top of that, we do have a unique record here, Your Honors. We have a general contractor with an incredible presence on site, 30 superintendents, 40 laborers. The general contractor's own employees brought our client into this crowded, overcrowded, according to them, loading dock area with multiple trades, lots of work going on. They directed him, the general contractor,
They directed
exactly
him
where to
to
go.
move also as well during the course of this. And that, when he moved to the second location was when he was hit on the head.
I mean, it turned out, I think, that he took his hard hat out, just hard hat off, just to go in the back and check something, and that's exactly the moment that the pallet fell on him.
Correct, because his hat wouldn't fit in the cab. So the general contractor workers literally directed him to the exact position where he was exposed to this falling object. There's no other case like that, frankly, to look at. It's a unique record. There's another fact that wasn't highlighted well, I think, in the underlying papers that I think is so important here and makes it much more fair to impose liability on the general contractor. There's testimony from J.T. Megan that on this project in general, on every single day except Saturdays, garbage was removed after the work was done at 3:30 p.m. But
So
they
counsel,
decided...
I'm going to ask you an important question. Are we talking about garbage or are we talking about construction debris?
Both. We're talking about construction debris.
Which is clearly linked to the construction work.
Yeah, I mean, everything that's being produced from this job site that's being thrown out, I guess, could be called debris or garbage. I'm sorry, I'm not sure if there's maybe I'm missing the distinction.
I'm wondering if you're missing the distinction.
I'm sorry, I'm not trying to be, yes, he's removing construction debris from the site. And the general contractor is the one that decided to create the conditions upon which this work was contemporaneous. They decided on Saturday, for some reason, that we should remove garbage and construction debris, quote unquote, all day. So they created the conditions of danger and contemporaneousness. There is no case that's been cited by the lower court or by my opponent that simply says debris removal is not covered by the labor law. The cases that are cited by my opponent are so easily distinguishable. They involve workers such as UPS delivery people who happen to be wandering into a building that's under construction, for example, and on and on and on. I could go through a computer technician, for example. The only other case cited by the lower court, Hernandez.
You can deal with that one on rebuttal, counsel. Thank you.
Thank you.
Good afternoon, Your Honors. Kevin Pollack from Fabiani Cohen Hall on behalf of the defendants.
So I have an important question for you.
Yes.
Is the removal of construction debris from a construction site while construction is going on an integral, is it integral to the work
No.
at the site?
I think in the record, I believe the term garbage and debris was used interchangeably. I think if you look at the pictures in the record at 7:15 to 7:16, what you'll see is a typical garbage truck you see on the streets, and you'll see garbage in the hopper.
Wasn't it in the record also that there was testimony that without the removal of the debris, the work would not be able to continue?
I don't think that's correct. I mean, it was a normal routine to remove the garbage from the construction site. I guess you can say that about anything. If you don't remove any garbage ever, I guess that's true. But this was just a typical.
Demolition was going on at the time, right?
No, there was no construction work that day.
No construction work that day. But
Correct.
was demolition part of the project overall?
I'm sorry?
Was
Yes, the
demolition was
project
part
as a
of it?
whole was going on, but that weekend, that Saturday, there was no construction work taking place at all.
They specifically asked him to come in the morning rather than the evening or the afternoon. So there was debris to be removed. There had to be something, no?
Yes, there was, in the loading dock area, there was debris from the construction. Yes, that was, it
So
doesn't remain on this, it
let's
doesn't remain there.
pursue that a little more. The debris was being loaded onto the dock while this worker was there, yes?
No, it was there already. The
was
garbage,
there?
the garbage was there. The truck came to remove the garbage from the construction site. And again, you have to remember, this is a garbage truck that's coming to take away garbage. It's
counsel,
not construction
I don't-
material.
I don't know about you, but the only garbage trucks I know all look alike. They just have different colors on the outside, and some of them have divisions on the inside, but you're trying to make a distinction, unless I'm wrong, between a garbage truck that removes garbage like paper cups and so on, and a garbage truck that removes construction debris. Or am I wrong?
You're wrong. There's no distinction.
It's the same thing, right?
This is just stuff that was being thrown out
And
and carted away.
Yes, and is there testimony that without the removal of debris, and I didn't see garbage in the language, I saw debris, from the loading dock, work could not continue?
I'm not aware of that testimony.
Well, why don't you look at the record at page 455, where
Yep.
one of the witnesses said that all material being disposed of was construction debris, testified that the construction debris was removed from the site so it doesn't build up, so there's no rat infestation, so that there's no fire hazards, so that there's no clear, so that there's clear pathways, there's room to build. And that he agreed that the removal of the construction debris is integral to performing construction at the construction site. In fact, he said, quote, "Yeah, you couldn't build a job if you didn't keep removing the garbage."
I don't see how that's
from a
relevant.
Mr. O'Driscoll.
I don't see how that's relevant to the issue here, whether or not the
Well,
plaintiff's
because it means that the work he was doing was necessary and incidental to the protected activity, which means that when the skid, which was at a height, fell on the plaintiff, that it should be covered by 240 of the labor law. That's what it means. And Rodriguez would appear to support that.
Respond, counsel.
Yes, I just want to make clear, I mean, this court has never held that a person driving a garbage truck is protected by the labor law. And which,
Counsel, it wasn't a person driving a garbage truck, it was a person who was there for the removal of construction debris.
He was operating
He wasn't driving.
the truck in the rear. He was operating the rear of the truck so they could push in
yes,
the
he
debris.
was compacting the garbage.
Yeah, compacting.
That's what he was doing. Again, the fact that he's there to collect the garbage, I don't believe that it's incidental to any construction work. And the cases in terms of Toro and Gentile and Hernandez, I think in order to, the plaintiff's asking you essentially to overturn those three cases and ignore them. I mean, I think those three cases clearly show that this activity was not protected. And in terms of Toro,
Thank you, counsel. We've all read Toro and given you a little extra time already, so thank you very much.
thank you, Your Honor.
I'm not asking the court to ignore those cases at all. I started out talking about them, in fact, and I'll just continue. The second and only other case cited by the lower court is Hernandez, and in that case, we have it's described as a chicken restaurant that's undergoing painting and plastering upstairs. The owner of the restaurant, not the general contractor, independently brings in a handyman to remove garbage waste from the basement, including stuff that has nothing to do with the construction project. This handyman is carrying a refrigerator, not having to do with painting or plastering work at all, up the stairs when he's hurt. It's easily distinguishable. Here, our client's company was hired by the general contractor. He was supervised, directed, and controlled by the general contractor. He's engaged in the same task as the J.T. Megan laborers that my opponent would want to be covered if they had happened to have been the ones that were hit by the pallet. They're doing the exact same task. They're standing shoulder to shoulder. Apparently, my guy was the only person in this crowded loading dock who wouldn't be protected by the labor law if he was hit by that object. I don't think that's fair. I don't think that's within the spirit of Pratt's. And we cite...
He was doing this work pursuant to a specific contract with the GC that said you come in on Saturdays and remove this as part of the project.
That's correct. You're going to come in, we're going to show you what to do, we're going to work alongside you and do this debris removal. It's only called debris in the record, I checked. It's absolutely only referred to as debris. That's exactly what it was, Your Honor. And of course, there are plenty of positive cases involving folks who, if you isolate their work and look at their job title, you wouldn't think they would be covered, but in a post-Pratt's world, of course, you are. This court in 2024, the Rodriguez versus Riverside case.
Well, that's the one I mentioned to your friend, where he was delivering tile. He wasn't even, he was delivering tile and to be installed, and he fell into a hole, and we held that it was covered.
Correct. In the other Riverside case from the same year, a plaintiff was merely delivering cement. The company wasn't even going to be pouring the cement. He was just delivering the cement, and then he fell from his own truck while he was washing his own truck. I mean, here we have someone who was, you could argue, not even really connected to the site at the time he fell, much less an object that Megan was supposed to secure, that they failed to secure, that fell directly on him because they told him to stand there. So for all those reasons, respectfully, we ask that the decision be reversed and that Labor Law 240 be granted in plaintiff's favor because the only evidence points to this object was unsecured.
Thank you, counsel.
Thank you.
Thank you both. People v. Vanderhorst.
Good afternoon, Your Honors. I'm Benjamin Weiner on behalf of Appellant Germaine Vanderhorst. There were no extraordinary circumstances that justified retaining this case in Supreme Court and depriving Mr. Vanderhorst of the essential family court services to which he had shown he was...
You say in your papers that we should not consider dispositions in family court, but hasn't this court in Messina already decided that we can consider that? Dispositions in family court in determining extraordinary circumstances?
I don't believe so, Your Honor. I think in Messina, the court had decided that the issue wasn't adequately preserved. And here, it is completely preserved.
Well, that assumes, well, even if it was, you raised a jurisdictional issue, didn't you?
Yes, Your Honor.
It's a jurisdictional issue, and we have to weigh in on that, whether this can be heard, even though there was a waiver, right?
Yeah, the appeal waiver, your point is that this is a jurisdictional matter that is not waived by an appeal waiver.
That is our position, that this is a jurisdictional matter.
There's a split among the appellate divisions concerning that point. Do you wish to address that?
I do, Your Honor. I think it's straightforwardly jurisdictional. The question is whether the youth part in the Supreme Court had the power to continue to adjudicate the case after according to our position, they erroneously determined that there were extraordinary circumstances. This is about the power of the court to hear the case. That is straightforwardly a jurisdictional issue.
Do you agree that the court made inquiry, court made sufficient inquiry in at least making a determination that there were extraordinary circumstances?
It did, Your Honor. Our contention is not that there was a problem with the process of adjudicating extraordinary circumstances here. It's that the ultimate outcome is wrong, but that is no less jurisdictional. The court incorrectly determined its own jurisdiction, and that presents a jurisdictional issue. And I think that's especially so on this record. I really would like to direct Your Honors to pages 8 to 9 of the plea colloquy, which is the part of the appeal waiver colloquy that discusses jurisdictional issues. What the court says is, to my client, is he could raise on appeal a claim that implicated, quote, whether or not me, the court, has jurisdiction or the ability to hear your case. I think given that this court hadn't weighed in on that issue, and given that the Court of Appeals hadn't weighed in, any reasonable person in Mr. Vanderhorst's shoes, even a lawyer under those circumstances, could understand that to have meant that this retention issue would survive the appeal waiver, because that was the only issue that had been litigated which had to do with the jurisdiction or ability of Supreme Court to hear the case. So perhaps there's an issue in a case down the line about whether this is always jurisdictional or not, but given that specific carve-out in the colloquy here, the appeal waiver shouldn't apply.
Could you?
Go ahead. Going on to extraordinary circumstances.
Right.
What can a court consider in determining extraordinary circumstances for retaining it in the youth court as opposed to sending it to family court?
Well, I think that the court can look to the nature of the offense, whether this is an unusually heinous kind of offense that suggests that the defendant will not be amenable to family court services. And I think
Counsel,
that's...
You're not answering the question, which has to do with a look back. Is there a point in time, or is there a type of offense of such nature that a look back is justified or required, and where that look back yields sufficient results to find extraordinary circumstances?
No, there's not, but that's certainly not true.
So you're saying there should not be a look back, that the initial inquiry is the offense presently before the court, and if that's, I'm going to use the term lightweight. Okay.
Sure.
And if that's lightweight, then you do no look back, you don't check to see whether there's extraordinary circumstances, you just act on the presumption that it automatically goes to family court?
Yes, but we don't need that to win this case, because I think even if the court looks back at my client's prior history in this case, there were no extraordinary circumstances based on that history, because the history showed that he was amenable to family court treatment. When he was in a limited secure placement leading up to this offense, he was doing extremely well. His caseworkers noted how engaged he was with family court services. He was getting treatment for his mental illness. He had returned to school, and this offense occurred when he was on an extended home visit in the community where he had experienced violence with no additional services in place. So I think what his history shows is this is a person who desperately needs family court services, who doesn't do well when he doesn't have those services, and should have been restored to those services in family court, and to allow the family court to determine, okay, what are home visits going to look like in the future for this person? Can they go back to the same place? Does there need to be a different placement? All of that would have been on the table for the family court, as well as restoring the services that seem to have been working until the point where my client was released into the community without any services at all.
Thank you, counsel.
Thank you.
Time rebuttal.
Good afternoon, Your Honors. Jamie Maston for the people. If I may just pick up the point of the last sentence that Mr. Weiner left off on, it's that we have in the record that the defendant was on a home pass from his limited secure placement. To me, that means that he was given leave. He was given visitation to his home. It does not, I think it's too much of a leap to say that he was simply dropped off at his house cut off from services altogether. I think there probably was a plan in place when that leave expired, and I don't think that he was probably absent any access to services whatsoever. And if I just may return to the jurisdictional question raised by Justice Stroman and Justice Moulton, I think one of the strongest reasons as to why this issue here is not jurisdictional is because there are two separate steps that are needed to get the case out of youth part and into family court. First, there must be a finding as to extraordinary circumstances, and that, this court has made clear, is a discretionary determination. The second step is that the court must actually order the removal, and the law is quite clear and heavily...
That I don't find such a strong argument, counsel. I mean, you would agree, you have to agree, that CPL 722.10 has a presumption that the youth court should give up jurisdiction to family court, right?
There is the presumption in the top of the sentence.
And there's legislative history, maybe it's just from the sponsor of the legislation, but even so, that this should happen in youth court, criminal court, should retain jurisdiction only 1 in 1,000 times, right?
I understand. If I might just go back to the question about the presumption, there is a presumption that the majority of these cases are going to be removed. Because the presumption is already into the statute, you don't need to...
The presumption is all about jurisdiction. That's why I have a hard time with your argument in your brief, which you lay out very carefully. This is all about jurisdiction. So therefore, how can an appeal waiver prevent us from considering it?
I understand. I think I would rely on our arguments on our brief that there is a two-step process. Just because the extraordinary circumstances determination is en route to the decision of who has jurisdiction over the case doesn't mean that the decision as to whether extraordinary circumstances exist is itself a jurisdictional question.
Let's say for the sake of argument that we disagree.
Sure.
Okay, let's talk about extraordinary circumstances. So in this situation, you have a 17-year-old with a loaded 4 millimeter firearm in his jacket pocket, and this is less than a year after the family court adjudicates him a juvenile delinquent. But he's in possession of a firearm. He displays it to other youth, and the defendant argues this is only simple possession of a weapon. It doesn't amount to extraordinary circumstances. How do you address that?
That argument only works if the test were based solely on whether the facts of the crime themselves were extraordinary. That is not the test. The test is a totality of the circumstances review as to whether extraordinary circumstances exist.
You could look
and
into...
it was, I'm sorry, it was a 9mm gun, it was loaded and defaced, and the defendant had bullets in a cartridge. Sorry.
You can look into the family court history.
Absolutely, because
And Guerrero, the Court of Appeals, makes clear that the youth part of the Supreme Court has that broad discretion to investigate and look into the extraordinary circumstances. Am I correct?
Absolutely. It goes to the common sense, apt conclusion that despite the leniency and services that the defendant was receiving in family court, it still was not having the desired effect of changing the defendant's behavior for the positive. He was still coming back to Justice Antignati's court the third, fourth, fifth time, again arrested on a violent felony offense. So it makes sense. It was an apt exercise of discretion for the court to say, look, what family court is doing is not working. We need to try something new. And if I may just signal...
As a policy point, I think it's a strong one that you're making, but it runs up against or does it run up against the Family Court Act, which prohibits the use of juvenile delinquency adjudications against an individual's interests except in sentencing?
No, not at all here, because I don't think the court was relying on anything appropriate. It was relying on its own observations of this defendant's history, what everyone in that courtroom was aware of, that this defendant had these prior cases, that he was getting sent to family court and he was coming back on these rearrests. The Justice Antignati himself had previously sent 2 cases to family court after a finding that no extraordinary circumstances existed. This was the 3rd time he was coming back.
With respect to this defendant.
With respect to this defendant. And if I may, Your Honor, just address that, I believe that Guerrero signaled that the extraordinary circumstances question cannot be jurisdictional. And if I may continue that answer.
Please.
Thank you. In preparing for this argument, I realized that there is a line in Guerrero that signals that this cannot be jurisdictional. And that line is, I'm going to quote mid-sentence, the alternative conclusion, meaning removal, would not have been unreasonable. And with that being true, the majority wrote, we cannot say that the court abused its discretion as a matter of law in determining that extraordinary circumstances exist. And what that means to me is that even if reasonable minds differ, the court was still willing to uphold the conviction. That cannot be true for a jurisdictional challenge because, of course, if there is merit to the jurisdictional challenge, then the conviction upon which it rests cannot stand. It's why you don't need to preserve it. It's why it survives a guilty plea. It's why it survives a waiver of appeal. But here, the court in Weir is signaling the opposite. Reasonable minds can differ on the discretionary determination as to extraordinary circumstances. We still can uphold the conviction. And that is why this question is not jurisdictional. Thank you so much.
3 points, Your Honors. First, on the extended home pass, because I really do think this is the critical fact in the case about his response to treatment. I'm quoting now from paragraph 31 of the defense opposition. It says, Mr. Vanderhorst was on an extended home pass from his placement with aftercare services to begin on February 27th, 2023. It's after the offense in this case. And quote, no supportive services had yet been put into place for him in the community upon his return home. That was not disputed below. That is a fact in this case.
But you're speaking prospectively. Isn't your friend speaking retroactive? I keep wondering if the word is retroactive, but you know what I mean, the look back.
No, my point is that my client, at the moment he committed this offense, was not receiving any services because—
But why did you say that he was benefiting from services?
Because prior to his release on this extended home pass, he was benefiting from the services. Everything showed that he was receiving treatment for his mental illness. He was engaged with services. He was going to school. His grades had improved. That suggests that he should have been returned to those services and restored to them. I also—
So he was doing well, and then he decided to possess a gun, loaded gun.
He did, Your Honor, and that is—
Despite all the services that he got.
He wasn't receiving services, though, at the moment when he
He did
decided
at
to
some
possess
point, right?
that gun. Prior to that, he had been receiving services, and that, to me, is the critical point, is that when he's receiving services, he's doing much better, and when he's not receiving services, he struggles again, and that's true of teenagers. That's the entire rationale of Raise the Age. And just in terms of the nature of this offense, if I may have a second to just finish up here.
Please, finish the thought.
Thank you. I want to contrast this with Guerrero. Gun possession is undoubtedly serious. We don't take that lightly for a moment. But Guerrero was a violent home invasion robbery that involved ski masks, being armed with guns and knives, taunting, Guerrero himself taunting the victim on social media after the offense. The offense here, there's no allegation that Mr. Vanderhorst engaged in violence or threatened violence.
Well, we saw the video as well. He's furtively showing his gun to his friends. It's not like any passerby could see that he had a gun. He wasn't holding it up in the air. He wasn't doing anything like that.
That's right, Your Honor, and this is the kind of serious but ordinary offense that the family court was set up to handle under Raise the Age. This is precisely what the legislature had in mind, precisely this kind of offense when they passed the Raise the Age law. So for those reasons, we would ask this court to reverse.
Thank you, counsel. Thank you both for a very lucid argument. Violia Energy v. North America v. OnWave. Please, counsel.
Good afternoon. May it please the court, Corey Stoughton for the appellants here. I want to present three key legal problems with the appellees and the commercial division's interpretation of the commercially reasonable efforts provision in this contract, where they concluded that as long as the purchaser appellees offered to renew the Venetian O&M agreement in 2019 on the exact same terms that were set at the last renewal in 2009, that per se satisfied the clause. The first problem with that is that it upends bedrock New York law, that determining whether there's been a breach of a contract's commercially reasonable efforts provision cannot be decided at a motion to dismiss stage.
Not cannot, just generally is not, right?
Cannot when it's an
You can see that
undefined
there are
term.
cases that do it on papers as opposed to after fact-finding.
Yeah, those are cases where the term is defined and the facts as alleged in the complaint establish that, but where the term is undefined, that is
Counsel,
by
how
design.
can the term not be defined when it says purchasers shall use, what is this, commonly, something reasonable efforts to obtain a renewal of each O&M agreement on terms and conditions, and then here's the important part, not less favorable than its existing agreement. That seems kind of black and white, doesn't it?
That is part and parcel of what they had to achieve, but that doesn't that doesn't mean that commercially reasonable efforts are necessarily given just because they offer the same terms in 2019 as in 2009. The reason why parties don't define, like have a specific contractual definition, a real specific benchmark for what commercially reasonable efforts means, the reason why they put that term into contracts is so that the behavior of the parties can be judged by prevailing industry standards at the time of the breach. They're allocating risk into the future because at the time of the deal, they can't agree on what the value of the company is because it depends on these future events.
Aren't you asking us to speculate on the intention of the parties?
Not at all, not at all. I'm just describing what language, what purpose the language like this in a contract serves in deal-making functions generally. But
isn't 5 years quite drastically different from 10-year term with the 5 years term renewable?
Yes, I think it is different, and that's why the Venetian reasonably exercised its contractual rights to say, look, going forward, we need different terms. We need 5-year renewal terms, and that was specifically anticipated by the parties at the time that this company was sold, because the Venetian had done that in the past, and the underlying agreement, the Venetian O&M agreement, allowed the Venetian to do that. And the error here,
So I found out what COMM means. It's not common. It's commercially.
Commercially
my own
reasonable.
notes, bad notes.
Yes.
Okay. So you're asking us to emphasize commercially reasonable efforts as opposed to on terms and conditions not less favorable than its existing agreement.
Can I stop you there? Because I actually want you to focus on both. And maybe the second error that I want to talk about really goes more to your concerns with the contract. Because the commercial division assumed that offering the exact same terms from the 2009 contract was per se commercially reasonable and no less favorable to the Venetian in 2019. But that was a premature and improper factual determination that contradicts what the complaint actually says. You can't assume that what was commercially reasonable and favorable in 2009 is exactly as favorable to the customer in 2019. This is an energy services contract. That's like saying that paying $2.50 for gas in 2009 is exactly as commercially reasonable and favorable to the counterparty as paying $2.50 for a gas in 2019.
That's a bad argument, counsel. If gas prices were the same as now as they were 10 years ago, we'd all be happy. And to renew it at the price that was available 10 years ago would be fabulous.
Well, exactly. Just like having a 10-year renewal term in 2019 would be less favorable, not just as favorable or no less favorable to the Venetian in 2019 compared to 2009. And so the commercial division's assumption that that is exactly as favorable to the Venetian, which is what the contract actually says, in 2019 was a factual determination and cut off appellant's ability to prove that actually offering a 10-year renewal term in 2019 is not exactly as favorable to the Venetian as it was when those terms were agreed in 2009.
Yeah, but we know that there's another section, 513D, which discusses your friend following a protocol to explain why they believe not offering the 10-year term hurts them.
Yeah, yes.
And explaining and potentially even mitigating to the other side how we can work this out, which your client rejected.
Well, that's right, but...
And so based on that section, that could arguably support the commercial judge's decision here.
But it doesn't for a couple of reasons, which is that 513D contained several prerequisites,
Which they
including.
complied with based.
But the complaint alleges that they didn't, and the facts alleged in the complaint show they didn't. They had to consult with the appellant, take reasonable steps to mitigate the commercial impact of the nation's revised terms, and establish that the appellee's conclusion that the terms are commercially unacceptable was reached, quote, reasonably and with reference to customary industry terms. The complaint alleges that it was not reasonable with reference to customary industry terms. That kind of phrase is exactly the kind of phrase that this court in Atlas MF and other cases said is a fact and context-dependent determination that requires a record about what customary industry terms are. The commercial division cut that inquiry off at the knees before it ever got started by assuming that the actions alleged in the complaint met customary industry terms when it didn't. And
Thank you, counsel. You have time to rebuttal.
Good afternoon, Your Honors, and may it please the court. My name is Michael Karlinski. I'm from Quinn Emanuel, Urquhart, and Sullivan on behalf of the respondents. And I don't think I'll need my 5 minutes because I think this is a very straightforward decision for this court to affirm the lower court.
You want to pick up at 513D since that's where your opponent just left off?
I'm happy to. Again, with respect to 513D, and I think Justice Shulman hit it right on the head, the complaint itself here literally alleges the elements of 513D, as the lower court found. It went through and it checked off the various elements under 513D, and the court concluded as an alternative basis that under 513D, the very complaint's allegations, this is one of those rare cases where the complaint itself factually pleaded itself out of a claim. If I can revert to 513A, again, there is a single solitary allegation here of breach, and that is you offered a 10-year term when the Venetian preferred to have both a 5 and a 10.
Venetian didn't say no to a 10-year proposal either, did it?
That's correct. In fact, what the record reflects, Your Honor, is that the Venetian indicated that it would consider 10.
But they did indicate that they were probably looking towards a 5.
They may have preferred. But the question for the court, of course, is did we comply with this provision? This provision has a benchmark, and I'm using Justice Cohen's precise language. This is the rare case where, unlike all of the cases that have said commercially reasonable efforts is the consummate fact question, here the very provision at issue defines with a benchmark for terms and conditions. Forget everything else, but there's no allegation that there was a failure of compliance for any other basis other than we offer 10 years. But here the benchmark specifically points us to terms and conditions no less favorable than the existing agreement. So the question, which of course the lower court confronted and this court should confront, is what was the existing agreement? There really is no dispute, it's 10 years. So how could you violate a provision where you comply with the language that says no less favorable than the existing terms and conditions by literally offering the identical contract,
in their reply brief,
services, et cetera?
Sorry, counsel. In their reply brief, they described that language you just read as a target, not as description of what is a commercially reasonable effort. Do you understand that distinction?
No, I don't. I think that this, again, is a benchmark. There's a definition for purposes of terms and conditions. That provision defines what we must do in order to be in compliance, which we did. If there were other allegations, if we offered different services, if we changed the economics, we might have a question here. None of those allegations are made in this case. The last point I want to make is that my friend raised this idea that, well, in 2009 versus 2019, maybe there's some difference in that. Argument was not made. It's an interesting argument, but more importantly, it is an argument that was waived. It was never made below. It's not in their appellate papers. I went back anticipating this argument to look to see. It wasn't even made at oral argument. So that argument is waived. Respectfully, you have two paths. I think they're both the right answer here, 513A, 513D. We ask that you affirm the trial court here. Thank you very much.
Thank you, Counsel.
I'll try to make two quick points. One is with regard to 513D. I'll just take one of its several procedural prerequisites. The complaint does not allege on its face that on Enway's determination that what the terms the Venetian wanted to renew on were commercially unacceptable was reasonable by reference to customary industry standards. It doesn't,
Sorry, I missed the last thing you said. Was reasonable what?
with reference to customary industry standards, which is a direct quote from what 513D required. 513D was their safe harbor, by the way, but those procedural requirements were bargained for to make sure that there were that Enwave couldn't just do exactly what it did, which is walk away simply because the Venetian asked for different terms in 2019.
But they didn't just walk away. I believe there were letters and proposals, and then I think I saw 2 of them, and then that ended with an email saying that we're sticking with the 5-year plan.
And the question is, did Enwave's commercially unreasonable actions cause that outcome? And the complaint alleges that it does. And discovery, a record should have been allowed to be developed to answer whether that was a true allegation or not, but it was pled in the complaint, and the commercial division cut that off. And respectfully, I would say the question, contrary to what my friend says, is not whether the existing agreement, whether the offer was the exact same as the existing agreement as it existed at that moment in 2019. The question, according to the words of the contract provision, is, was Enwave's offer in 2019 not more equally as favorable to the Venetian as the terms as they were accepted in 2009. And that argument isn't waived. That has been the argument from the beginning, that they did not act in a commercially reasonable way. They did not account for the fact that the Venetian made a reasonable adjustment to the terms as it had a contractual right to do. They even asked for clarification about whether this was important. The Venetian said it was, and they ran right through that, said we're only going to do the same terms we've already done, and it was rejected.
But I'm confused. You keep saying less favorable, no less favorable to Venetian as opposed to no less favorable to the purchaser.
That is correct, Your Honor, and that's because that's what the contract says. It says, and I'll quote, it's at the record at page 281, the renewal agreement has to be offered on terms that are similar, substantially similar scope of services and terms and conditions no less favorable to the customer. The customer in here is the Venetian. And that's critical. I think a lot of their argument turns on that kind of muddling confusion. The question is whether the terms that they offered were commercially reasonable and no less favorable to the Venetian in 2019 compared to what was agreed in 2009. And again, that's why the gas price analogy makes sense, because—
Thank you, counsel. Thank you for your briefs. Thank you both. Torres v. Ioino.
Tasha Ayers on behalf of the appellant. This is an appeal of plaintiff's motion to strike the affirmative defense of comparative negligence. In this case, the only testimony that bore on the issue of comparative negligence came from the defendant. He said 2 things which are really important here. Number 1, at page 309, he said that he came out of a parking lot and she was already almost past me. So there was nothing for her to see in advance.
Let me ask you about something that the plaintiff testified about, which is that she did not look to her left for 5 seconds before the collision. Is that important?
It's not, because the question was about the stop sign. And she also said at that very same line of questioning that when she was driving, she saw nobody on her left at the stop sign. Then the follow-up question was, did you actually turn your head, look to the left? And she said no. But in this case, he wasn't at the stop sign. He was at the parking lot and exiting the parking lot. And that's what she didn't know, and that's why she didn't see him. He was behind her, and he admits, I came out of the parking lot at 309 lines 2 through 4. He said, she was already almost past me when I exited. The second portion of the testimony which came relevant on this is, where was she on the roadway? Was she partially at fault for being weaving in and out of traffic or in the middle of the road?
He has repeatedly testified he didn't see her.
He didn't see her before impact, but so he couldn't have seen her weaving in and out of traffic. But second of all, he said when he was asked, at page 309, lines 23 to 25, he first said she was more in the center of her lane, of traffic when he hit her. Then he said, or maybe she was more in the middle. And then he candidly admitted at page 310, lines 5 through 7, it appeared to me, I don't recall. Again, you're talking 2.5 years ago. I really can't say for sure. So the jury would only have speculative testimony to think that there's comparative negligence. And this, in light of the fact that this defendant destroyed his own accident report, he hand wrote on the day of the accident and turned into his boss at Hertz. He saved a copy for himself. Hertz never turned it over in discovery, and the defendant himself couldn't find it.
He also said, I just turned too soon, right?
He said he turned too soon. And one thing he said about the photographs he took post-accident is very relative, because he said he took 3 photographs. One was of the plaintiff's vehicle. Then he was asked, what other photographs did you take? And one of the other photographs he said he took, he was of the roadway she was traveling on in the right lane. So I asked at page 298, line 14, so the photograph you took was the roadway she was traveling on correct at the time of the accident? He answered, yes, right, on the right side of the lane.
Thank you, counsel. You have time to rebuttal. Counsel, just before you give your appearance, we're doing a courtesy by allowing you to speak because you weren't here on time for the calendar. So please make an effort next time to be here on time for the
I
calendar.
do apologize, Your Honors, for my tardiness today. May it please the court, Donna Brodigan from Pillinger Miller Tarallo for the respondent. I just want to point out that the actions of my client are really not what is at issue. It's whether or not the plaintiff herself had culpable conduct for any portion of the happening of this accident. Her testimony is clear. As she's entering into an intersection, she never turns her head to look where she knew there was a parking lot, where she knew there are streets with stop signs and traffic would be coming off of those roadways.
So is a driver who's driving straight supposed to look every time that they see a parking lot to their left or right?
I don't think it's a law that you would have to look, but I think as you are traveling in an area where you know that people will be coming in and out of parking lots,
what about a driver who's got right-of-way?
even with the right-of-way, Your Honor, you still have your own
Counsel,
responsibility.
wouldn't that turn VTL, sorry to interrupt you, but wouldn't that turn VTL 1143 on its head? That's the one where you know, when you leave a parking lot, you're supposed to watch where you're going.
Yes, and I understand the person coming out of the parking lot also has the responsibility to look to see whether or not there are any cars coming
And to
past
yield,
them,
and to yield.
see what is there to be seen, and
right.
to yield the right-of-way.
Right.
Someone also have to look to, while she's past the parking lot and entrance and exit, to see who's coming out after her?
She does not have to look behind her, Your Honors. It's as she is approaching the entrance or exit to a parking lot, to glance to the left to see if there's any cars that are coming out, to be aware of her surroundings, to know whether
But a driver who has the right-of-way, the person that's going straight, is entitled to anticipate that excuse me.
So
Please continue. Oh, go ahead.
yes, so Sanchez says that a driver with a vehicle that has the right-of-way is entitled to anticipate the drivers entering the traffic flow will yield.
yes, they do have that, but they also have to be aware of their surroundings and see what is there
I
to
still don't understand any basis for comparative here. If she's in the right of way, keeping in the right lane, going the right speed, doing everything right, no pun intended, and the defendant was making the left turn who should have exercised caution based on the VTL. I still don't understand it. Moreover, even the claim that your client may have seen her weaving or something to that effect, but then on 311 of the record, he said he didn't see her on the unobstructed road until the point of impact. I mean, this is he's making stuff up here. It doesn't seem to make sense, counsel.
Yeah, and then the record, just piggybacking on what my colleague said, he said that he saw the plaintiff for the first time when he came out of the parking lot just at about the point of impact. So there's all these inconsistencies.
There
How
are
do you address that?
inconsistencies in his testimony, yes, there are, Your Honor. He's at believe he's 86 years old. Yeah,
How old?
I believe he's 86 years old, if I'm not mistaken, when he was giving his testimony. It was 2 years ago when the accident happened. Did he have the clearest of memory? No. But for our purposes today, it's whether or not the actions that the plaintiff took that day, if any of that would have contributed to the happening of this accident. If she would have looked, would she have seen the vehicle at the exit to the parking lot, beginning to enter onto the intersection? Maybe if she had turned her head, would she have changed her speed? Is there any culpable conduct on her for those actions on that day of what she was doing in her vehicle before there was any type of impact?
Thank you, counsel.
Thank you.
Your Honor, may I just very briefly?
Please.
Sure. Judge Kapnick, in the case of, is it Picardo versus Irizarry, Irizzary, 2023 decision, specifically said a driver does not have a duty to look behind them. And that was a lane change case where the vehicle changing lanes struck the rear portion of the vehicle, which is exactly what happened in this case. It wasn't a lane change, but here, the defendant testified is as she was passing me, he pulled out of the parking lot. And the damage to the plaintiff's vehicle, he admits, was to the rear of her vehicle. There is no duty to look behind you as you were driving. And any other testimony about weaving or where she was on the road is pure speculation that shouldn't be considered by a court because he doesn't remember. And for God's sake, he destroyed his own accident report and destroyed all of his photographs. There should be no comparative negligences in this case. Thank you.
Thank you, counsel. Thank you both. People be Javi Dore.
May it please the court, Jacob Arbor on behalf of appellant Javid Dor. The key facts here are not in dispute. Both parties agree about the extent of the injuries the complainant testified to. The only issue here is whether those injuries, soreness, slight swelling, some bruises and scratches, and a cut on the lip, amount to impairment of physical condition or substantial pain. They do not. There's a few reasons that we know that the minor injuries here did not
We don't need medical records necessarily to evaluate whether an injury is sufficient, correct?
No, you don't need medical records. But the medical records here are clear that the injury was not sufficient. If you look at the medical records, Your Honor, they indicate that the reason that the complainant went to the hospital was not because of the injuries, it was because he wanted to get tested for HIV and hepatitis B.
He did that, but he also was treated for his bruises and cuts, wasn't he?
He was discharged from the hospital to home care for just icing, so there really was no treatment at the hospital.
And he got antibiotics, do we know that?
There's no indication that he received antibiotics. The medical records don't reflect that. And actually, if you look at...
I think he testified to that, though, didn't he?
He testified that he was taking medicine for a heart condition, but I don't believe that...
Okay, thank you.
Perhaps he did say some
Didn't he
ointments.
say in the transcript at page 65 therein that at the hospital his wounds were cleaned and he was prescribed antibiotics for a few days as a result of the attack? He also missed quite a few days of work. That's different because he had no ID.
That's correct, Your Honor. It did say antibiotics. I misspoke. But with respect to the missing work, he did say that the reason he missed work was because he had lost his ID and not because of the injuries he suffered. And
He lost it, or the defendant took a bag with the ID?
the defendant did take the bag with the ID, but that's not relevant.
That's not losing something.
It's no longer in his possession. That's fair, but that's not relevant to the inquiry of substantial pain or impairment
This is
of physical
true.
condition. And with respect to the medical records, Justice Moulton, the medical records indicate that he was, quote, atraumatic. There were no intraoral injuries. There were no indication of a problem with the abdomen, no shortness of breath, and the only injuries reflected in the medical records were, quote, a bruise noted to left elbow.
So the complainant testified that he was choked, punched, and kicked. He was sore everywhere. He showed the court a scar on his arm and bruises on his right elbow and both knees, which persisted, notwithstanding the passage of time. The police took him to the hospital. Yes?
There's two parts to that, Your Honor.
Please.
With respect to the testimony regarding the actual conduct, the choking, the hitting, That's not really relevant to the question of whether the complainant himself experienced substantial pain or impairment of a physical condition. The question is, what were
So you're
his
saying you can be choked and not, not experience substantial pain?
It is entirely possible, and on the record here, where there was no bruising around the neck and no injuries reflected in his medical records to the neck, I think there's no evidence to support the conclusion that it would have caused substantial pain. As to
So you have time in rebuttal as well.
Good afternoon, Your Honor. It's Joseph Tuck for the people. What Mr. Mborik suffered here was more than just mere petty slaps and shoves and kicks, but a sustained 10-minute attack. He was attacked from behind in the dark. He was choked. He stated that he lost his breath, that he was choked so hard that he felt like his neck was going to break. He was slammed to the ground where he banged both of his knees, his elbow. He suffered bruises and lacerations to his elbow and to his knees, which he still had 2 years.
And didn't he say that he felt sore everywhere and he had some bruises or something still on his arms at the time of the trial even?
Yes, that's true. And he testified that he was
How
sore
much
on his...
time?
Excuse me, I'm sorry.
How much time between his appearing in court and showing the
He
scars?
testified 2 years after the attack, and he still had scars on his elbow, and he was going to show the jury scars on his knees. He testified that he felt like his chest was going to explode. He was choked when he was on the ground, that the defendant's finger slipped into his mouth, and he was so desperate to escape the attack that he bit down on the finger, causing him to bleed. The police got DNA from that. It matched the defendant's. The jury heard about the DNA
There was
evidence.
blood on the jacket.
Excuse me?
There was blood on his
They
jacket.
found the blood on his jacket from the defendant. It matched the defendant. There was medical testimony that afternoon, the defendant went to Harlem Hospital and was treated for an injury to his right index finger and a fracture to his thumb. The jury heard about that evidence, saw pictures of the injury, and heard the DNA evidence. And I would argue that the conviction here was based on legally sufficient evidence and was not against the weight of the evidence. If there's no further questions, I'll rely on the brief, Your Honor. Thank you.
Thank you, counsel. Please.
Your Honors, the question is not whether the ferocity of the attack was particularly ferocious or what the jury might have understood about that. The question is whether there was substantial pain or impairment of a physical condition. And this court has made clear, the Second Department made clear in People v. Jagru, which we cite in our reply brief, that even being pushed to the ground and slapped several times in the face without testimony related to the duration of the pain or whether there was medical treatment sought is insufficient to rise to that level.
You know, this is not the Second Department, right?
It is not, but there are plenty of cases from this department as well indicating that the types of injuries here are insufficient.
Yeah,
This
but the jury, from his testimony, there's case law that supports that the jury could infer the pain was substantial from his testimony, and it could even be based on his subjective description of how he felt. I mean, it's...
There's two parts.
So his testifying, all that he testified there 2 years later, they can infer that he went to hell at the time of the attack.
There's limits to what the jury can infer, and what the jury can infer is to his experience of the pain. But as the Court of Appeal indicated in matter of Philip A., there's an objective level above which the injuries have to rise for that to even be considered. And here, it doesn't rise to that level. We point this court to People v. Brown. There, a conviction was reversed where the complainant was bleeding, felt pain, sustained cuts and abrasions, and went to the hospital after he'd been hit in the head with a gun. And the court still said that that was insufficient to prove substantial pain.
How about People v. Clark that said that a scar can establish an impairment of physical condition?
The scar itself, when there's no testimony regarding the level of the pain or the other circumstances surrounding the scar, are not sufficient.
But I thought he did testify that he felt sore all over his body.
Soreness alone is not sufficient to rise the level of substantial pain.
This is what they heard. They said he was first strangled, then he was repeatedly kicked in the back and kidneys, punched multiple times in the head, cheeks, necks, and shoulders. I mean, that's a whole lot of abuse, physical abuse.
But again, Your Honor, the question is, what was the actual substantial pain or impairment to the complainant, not what the defendant may or may not have done. to the complainant.
Thank you for your presentation, counsel. You did this pro bono, did you not?
Yes, Your Honor.
Thank you very much for your service.
Thank you.
Thank you both. Board of Managers v. 56th and Park. Please.
Good afternoon, Your Honors. Glenn Monahan with Ovid and Oved on behalf of Appellant. At issue on this appeal is the lower court's denial of summary judgment seeking dismissal of respondents' two counterclaims seeking intra-party indemnification.
Right.
Well, because,
Go ahead, please. Okay, and the indemnification provisions make no reference to intra-party claims, correct?
No reference whatsoever, Your Honor. And under the Hooper decision, the Sage decision, and this court's more recent Needham decision, it's clear that he is not entitled to indemnification.
Except, let me ask you about this inference that one can draw from the indemnification agreements. They relate, or they mention self-dealing. Who else is going to be able to sue you except for the board if you self-deal?
Well, they don't actually mention, the indemnification doesn't actually mention self-dealing. It's a carve-out of liability, which is not indemnification. If it was, then any agreement that had a limitation on liability would be read to provide for intra-party indemnification, which is plainly not the rule. And in fact, the court in Sage said that just because you have a broadly written indemnification provision does not mean that you are entitled to intra-party indemnification.
We are allowed to draw inferences, though, are we not, in interpreting such provisions?
Your Honor,
it doesn't have to say you can sue the board, right?
There's no specific, the Court of Appeals hasn't said you have to have this exact language. But what it has said is it has to be unmistakably clear. And what the Court of Appeals said in Sage is to the extent that some of these decisions presume that broadly worded indemnification provisions by their nature are intended to cover attorney's fees and direct party actions, they deviate from this court's exacting standard that the agreement must contain unmistakably clear language of the party's intent to encompass such actions. There's nothing of the sort here. So what does respondent resort to? Respondent is resort to saying they're broadly worded. I just dealt with the fact that that does not fly. That there are liability carve-outs that somehow mean that there's a default right to intra-party indemnification. First, as I said, a liability carve-out is not indemnification, and it's not unmistakably clear from a liability carve-out that the parties intended to deviate from the American rule or waive the American rule, that there's no intra-party indemnification. Their final agreement is that there's multiple indemnification provisions, and thus there's some sort of ambiguity. Well, first, if there's no ambiguity, it's not unmistakably clear. But putting that aside, there is no ambiguity. There's 3 indemnification provisions spread across 2 different agreements. First, in the condominium bylaws, there's an indemnification provision that provides indemnification to the board, not to individual members. Then those same bylaws do indemnify board members for claims arising out of their service, unless they acted in bad faith, gross negligence.
Can we deal with that part, counsel? Was there bad faith, gross negligence, or willful misconduct evidenced here?
That's what was alleged, Your Honor. And that's what we will intend to prove on behalf of our claim. But with respect to whether or not he's entitled to indemnification, even if there wasn't alleged that there was bad faith, gross negligence, or willful misconduct, he still would not be entitled to intra-party indemnification under the Court of Appeals standards, which this court upheld in the Needham decision in 2023, in which the court expressly said the indemnification clause in the contract between plaintiff and defendant does not explicitly require defendant to indemnify plaintiff for expenses arising out of plaintiff's breach.
So I don't understand why you don't want to discuss whether there was bad faith, gross negligence, or willful misconduct, because aren't those the triggers?
Those would
for
be the
indemnification where there is self-dealing. Self-dealing is allowed. Self-dealing is allowed so long as there is no bad faith, gross negligence, or willful misconduct.
That's correct, Your Honor.
So was there such here?
Yes, Your Honor.
And what was it?
The respondent's self-dealing?
Yes, please. No, not the respondent's self-dealing. The bad faith, gross negligence, or willful misconduct.
The manner in which he did it was to enrich himself at the expense of the unit owners and the board. This wasn't something that didn't have an effect on that, where he was allowed to compete, he was allowed to enter into other agreements, something of that effect, which would not harm. But the fact that you're doing something that actively harms the very unit owners whose interests you're supposed to represent.
And what was that harm?
This entire lawsuit arises out of a defective construction of a building. There were over 1,000 defects alleged. There's almost 200.
But particularly, we're dealing with the electrical work, that they were doing electrical upgrades in the commercial units, and in doing so, they did so while the electricity was live.
The electricity was live.
And it is alleged that Mr. Macklow played a very important role here in making this all go forward at risking all the entire building and its unit owners.
Correct. And in fact, it ultimately resulted in a construction worker getting incredibly injured, but that's a separate lawsuit that's being handled with insurance. So what Mr. Macklow did was put his interests above the interests of the entire building, of the unit owners, of everyone to line his pockets.
So assuming arguendo, there was indemnification, what my colleague was raising here, given these kind of allegations, it wouldn't kick in anyway.
It wouldn't kick in anyway, but my whole point was you don't even need to get to that because it doesn't reach the standards enunciated by the Court of Appeals that this court has adopted as it must adopt. And I see that my time is up, so I'll
Thank you, counsel.
to my colleague. Thank you.
Thank you, Your Honors, and may it please the court, Rich Trotter from Forrestine Kulik on behalf of the respondent, Mr. Harry Macklow. I'd like to pick up with a point that Your Honor raised right off the top of my friend's argument, which is that the indemnity provisions, of which there are 3, each with distinct language in various parts of the governing documents that govern the operations of the building, refer to liability to the unit owners and self-dealing. As Your Honor pointed out, there is no one else that could raise a self-dealing claim against the board members other than the unit owners. And while Hooper does require unmistakably clear intent, Hooper and its progeny, including Sage and various other cases cited by the appellant, make clear that implied indicia is sufficient to meet that burden of unmistakably clear. To Your Honor's point again, it need not be explicit. My friend overstates the holding in Hooper, and the progeny applied by this court shows that there is more nuance to the application of these indemnity provisions than appellant's argument would have the court believe. For example, the decision by this court in Shaw from 2021, in which there were multiple indemnity provisions within the same contract, no explicit language providing for intra-party indemnification per se, but the existence of the multiple indemnity provisions, together with their distinct language, gave rise to an unmistakably clear inference of intra-party indemnification. I think the other critical point here is that this was at summary judgment. And the IAS court denied appellant's motion for summary judgment because there is no extrinsic evidence which would support their interpretation of the 3 indemnity provisions. At a bare minimum, you have 3 separate provisions, each with distinct language, 2 of which contain references to concepts that are clearly intra-party in nature, liability to the unit owners and self-dealing. At a bare minimum, that creates an ambiguity that appellants failed to carry their burden of resolving at summary judgment. It's well established that Hooper and Sage and its progeny aside, they do not supplant the general contractual principle that it's the court's job to interpret the language of the agreement and to discern the intent of the parties based on that language or based on extrinsic evidence.
I always thought, and I thought subsequent cases have said, that the standard imposed by Hooper is really a very strict standard. And so you can't be, always saying, well, maybe it's a possible, that's good enough. It is really a strict standard.
It is a strict standard, Your Honor, but it also has to be counterbalanced against the appellant's burden at summary judgment of resolving an ambiguity. Even in Hooper, the court says that the principle of affording meaning to all of the provisions of a contract is not supplanted by the Hooper standard. In fact, that requirement of interpretation continues. And that was the holding in Shaw, that in order to afford meaning to the multiple indemnity provisions, appellants offer no cogent explanation for why there would be 3 indemnity provisions to provide for the same third-party indemnification rights. Effectively, they want to read 2 of those 3 provisions out of the agreement altogether. They offer no cogent explanation for why 3 indemnity provisions would be required to provide the same indemnity right. And so at a bare minimum, Your Honor, that creates an ambiguity that was not resolved at summary judgment.
I don't know, if we dealt with that, if that, your redundancy argument was correct, we would be never having any inter-party disputes in co-ops and condos. I mean, they're often, I'm being a little loquacious here, the bylaws often are redundant of other operating documents that concern residential buildings in New York City. So I don't really see the redundancy argument unless there's some conflict between the various indemnity provisions.
Yes, Your Honor, that's a great question. Can I address that directly?
Please.
In the condominium bylaws, there's section 211.1 and there's section 1110.1. 2 provisions within the same document, right? The same condominium bylaws with distinct language.
They both have the bad faith, gross negligence, and willful misconduct language, right?
Correct. And we do not, by the way, we do not dispute that should appellants prevail. I believe Your Honor asked a question to this effect, if I may finish my response. Thank you.
Yeah.
That should they prevail in proving bad faith, we do not believe they will, then Mr. Macklow would not be entitled to indemnification. However, as the IAS court found, should Mr. Macklow's version of events prevail, there's a question of fact that he would be entitled to indemnification, and so summary judgment was properly denied. Thank you, Your Honor.
So I wondered if you could, since counsel sort of asked you to, give us a cogent reason for why there are these 3 separate indemnification
No problem,
clauses.
Your Honor, of course.
Thank you.
The first is in the offering plan, which under section Q5 on page 868 of the record, in a heading liability of condominium board and unit owners, carves out certain liabilities, including for self-dealing, and then in a separate sentence says, all unit owners shall severally, to the extent of their respective interests in the units and their pertinent common interest, indemnify each condominium board member against any liability or claim, except those arising out of bad faith, gross negligence, or willful misconduct of such member. That's the indemnification for when you're sued under the offering plan. That's one. Number 2 are the indemnification provisions in the bylaws, which relate to the governance of the condo. The indemnification in 2.11 is for the individual board members, whereas the indemnification in section 11 is indemnifications due to the board as an entity, not the members. So there is the reason for 3 different indemnity provisions spread across 2 different provisions. They cover different things. With respect to the Shaw decision, that predates Sage. Sage just didn't reiterate Hooper, it strengthened Hooper, it sharpened Hooper, and it made clear that this is the exact type of lawsuit that is not allowed to go forward under New York law, because there is nothing in any of these provisions that even references disputes between the parties, intra-party disputes, prevailing party is entitled to fees if he wins in an action among the parties. Nothing. There is no reference to it whatsoever, such that it is not unmistakably clear. To the contrary, it's unmistakably clear that it does not provide for intra-party indemnification. If the court, my time's up, so I will yield.
Any other questions? Thank you, counsel. Thank you both.
Thank you very much.
People v. State of New York, the National Rifle Association. Please.
Good afternoon. May it please the court. Kent Correll for Wayne LaPierre, the appellant. The court below entered a judgment that was mostly right, and Mr. LaPierre is seeking to have an error corrected. With respect to the second cause of action, Justice Cohen directed payment by Mr. LaPierre to the NRA, conditioned settlement or compromise of the amount of the payment on judicial approval, and then barred Mr. LaPierre for a decade from serving as the executive vice president of the NRA.
Which one of those do you want to deal with first? Which of those do you wish to deal with first?
Whichever you prefer, Your Honor.
Well, let's talk about the 10-year ban. One thing you say is that it violates his First Amendment rights. And it seemed to me that wasn't a powerful argument because he still is able to associate with the NRA, and he's still able to speak out on behalf of the NRA's causes. He can raise money for the NRA. So what is the impediment?
Your
on his
Honor,
or what is the infringement of his First Amendment rights?
the bully pulpit has been taken away. It would be like suggesting that someone can't run for president of the United States. As the EVP of the NRA, he speaks for 3 million people. He can communicate with them in weekly dinners around the country.
And nobody breached his fiduciary duty. A jury found that. So you don't want him to be head of the EVP. You want him to be the effective CEO of the NRA anymore. One does not. I mean, or the law does not.
Your Honor, I would urge the court to look at the verdict sheet and see what the verdict sheet actually says, what the jury actually decided. The question was cast very broadly, question 2A. At any time, do you find that the plaintiff, do you find that at any time during the period from March 22nd, 2014 to May 2nd, 2022, the plaintiff proved by a preponderance of the evidence that Mr. LaPierre failed to discharge his obligation, his statutory obligation, in good faith and with the care an ordinarily
You have a good memory, counsel.
in a similar position.
But the record was replete with breaches of fiduciary duty. That was in front of the jury, and that's how they reached their verdict, I presume.
Your Honor, the question that was not put to the jury was whether the plaintiff had proved by a preponderance of the evidence facts sufficient to support the cause of action alleged, the second cause of action. And there was also no question to the jury of whether the plaintiff had proved by a preponderance of the evidence that Mr. LaPierre had acted with knowledge of unlawfulness with respect to anything, any act or omission, any transfer, any transaction. And
So when he took the $4.5 million roughly for his family and friends and et cetera, unrelated to any NRA business, you think he didn't have the intent or didn't understand what he was doing?
Your Honor, that was not the jury's finding, and if you look at the verdict sheet, there's no finding of fact to that effect. And the fact is that there's not even any evidence to that effect, because the vague allegations were that mainly that a bankruptcy proceeding was filed by lawyers in Texas, and that Mr. LaPierre directed that. He did that after consulting with a special litigation committee that was appointed by the NRA board, who was advised by NRA counsel. And part of the theory was that he shouldn't have done that, and he should somehow bear responsibility for that.
Counsel, there's no issue as to NRA funds being used to fund family vacations in the Bahamas using a private jet?
Your Honor, the evidence was that Mr. LaPierre had a security issue. He had to fly private everywhere.
But how much did he have to pay by way of restitution as a result of that allegation?
What happened was...
No. What happened? How much did he have to refund?
There was no finding of any particular amount with respect to any particular act or transaction, and that was the problem.
Who decided the issue of restitution?
Well...
The dollar amount.
If you look at the verdict sheet...
No, just tell me, it was jury, judge, nobody?
The jury decided it on the basis of a question that was so vague as
That's
to
the
offer no
verdict,
guidance.
right? That's a verdict. There was a determination of malfeasance, and as a result, restitution had to be effectuated, yes?
The word malfeasance does not appear in the verdict sheet. A lot of words have been thrown around. Malfeasance. The only finding the jury made was a violation of 717. And that mistakes the duty of a director, officer, or key person to the corporation for liability. 717 sets up a standard of duty and a safe harbor, immunity. If you allege a violation of 717, that means you get past the business judgment rule. It doesn't mean you've got liability under 720. They did not prove a proper cause of action under 720 that would give them any entitlement to monetary relief at all. So the question was not the proper question to ask if you're seeking monetary relief. They didn't ask the right question. The right question was, did he act with knowledge of unlawfulness with respect to anything? And I asked the court to submit that question to the jury. He refused. I objected. He overruled the objection. The Attorney General said, we're not asserting a cause of action under 720A2. In Grasso, this court said in 2007 that knowledge of unlawfulness was an element. I see my time is up.
Sorry, finish the thought, counsel.
That knowledge of unlawfulness is an element that must be proved to get money from a former officer of a not-for-profit corporation. It is the most difficult element to prove. They didn't even try to prove it. If you look at the complaint in the Grasso case, they alleged a 720A2 claim along with a 720A1 claim. 720A1 gives you the right to compel the defendant to account for his official conduct, meaning explain, provide information.
Right, we'll deal with that. I'm going to ask your opponent about that question as well, but you'll have a chance to talk about to account on your rebuttal.
Thank you, Your Honor.
May it please the court, Matthew Grieco on behalf of the people. This court should affirm Supreme Court's judgment. On appeal, Mr. LaPierre challenges only the legal availability of the remedies granted in the judgment. His arguments are meritless. I'll begin with sections NPCL, section 717 and 720. Section 720A1 codifies an action requiring an officer to reimburse a not-for-profit corporation for monetary harm caused by the officer's failure to discharge his duties in good faith and with ordinary care, which are the duties imposed by section 717. And we know that section 720A1 requires reimbursement for many reasons. To begin with, in the context of corporate governance, the word account is a term of art to codify an action for an accounting.
So as I understand it, your friend suggests that he can credibly account for his actions by just giving some kind of explanation, even if he stole all the money. I'm just being colloquial about it. I'm not saying he stole anything, but you understand what I'm saying. Does that make sense?
It does not. And the only way the statutory scheme is coherent is if account is read, given its usual meaning in the context of corporate governance, meaning an action for an accounting. Mr. LaPierre's interpretation that to account for means to explain oneself is not plausible. It's not credible that the legislature would create an action in which the plaintiff's remedy...
It also would have been very easy for the legislature to use the word restitution in the section.
Well,
to account and provide restitution. In fact, Mr. LaPierre cites a number of statutes that talk about to account and to pay amounts that were, that should be disgorged because of some violation of that statute. So that's in his brief on page 5. He mentions the EPTL, education law, public officers law. They all have the additional to pay or do restitution. So how do we interpret that?
So I have two answers to that, Your Honor. First of all, we know from the Court of Appeals' decision in Ederer versus Gursky and its consideration of partnership law section 74 that the word account without more can be sufficient to create an action for an accounting. The partnership law section 74 also uses the word account. There's no separate reference to payment, and the Court of Appeals said an action for an accounting is restitutionary by definition. So Ederer squarely rejected the very same argument that Mr. LaPierre is making here today. Second, and in any event, even if Ederer didn't control, which it does, the statutes that Mr. LaPierre is relying on in his reply brief deal with a different kind of circumstance. For example, NPCL section 715F1, which he cites, which is a statute relating to related party transactions. That statute applies is not targeted at fiduciaries. It's targeted at any person or entity who may have received assets from a related party transaction. Since that statute isn't tied to a fiduciary duty and an action can be brought against any person or entity, it was necessary for the legislature to delineate the exact set of funds that could be potentially compelled to be paid over, in that case, profits from the related party transaction. It's not necessary to include that separate language here because a fiduciary, by nature of being a fiduciary, is already responsible for all of the assets of the corporation at that time.
Did the jury make a finding about fiduciary duty? Because it sounds like your opponent thinks not.
Well, it did. If you look at the jury charge and you look at the verdict sheet, it is exactly the standard that is set forth in 717 that was charged to the jury. Now, the mistake that my adversary is making, this gets to his reliance on Grasso, and I know we're running low on time, but I do want to take some time to address Grasso because he relies on it heavily, but Grasso actually confirms that our position is correct. Grasso made clear that there are two different fault-based standards. And when I say Grasso, I'm referring to both this court's decision and the subsequent Court of Appeals affirmance in Grasso. the standard under A1 is breach of the duty of good faith and ordinary care set forth in 717. The standard under A2 is the standard, the knowledge of unlawfulness standard that my friend has been referring to. But of course, that knowledge of unlawfulness standard, even when it applies, it's not talking about the officer or director, it's talking about the transferee. That is a separate provision that has nothing to do with an action for damages or accounting. That is an action for rescission, to rewind one specific individual transaction, not to hold someone accountable for a breach of fiduciary duty. The sole holding of Grasso is that the Attorney General cannot substitute a common law standard for a statutory standard. But of course, the record shows quite clearly that we did not do so in this case. The jury was charged on the standard that is in 717 and incorporated by reference in 720A1. And I would say, by the way, that both this court and the Court of Appeals in Grasso recognized that the section, that the standard set forth in 717 is the standard that is incorporated in 720A1.
Any other questions? Thank you, counsel.
Thank you.
Your Honor, Grasso said that the knowledge of unlawfulness is an element you have to show to get money from a former officer under 720. And on that basis said, because these causes of action are devoid of that element, you can't pursue them. The implication is you've got to prove that to get that relief, and that was the ground on which they disposed of the other causes of action. The partnership law, why look to the partnership law to borrow a definition when you've got the revised statutes, the first codification of statutes in the country that used the word compel payment or compel the defendant to account for his conduct and then compel payment for 150 years, and then they dropped it out in 1969 when they enacted the MPCL.
But if to account means to explain, what's the utility of that?
The utility is to determine whether you have a cause of action under 728.2 or under 750.
Then what do? You bring a replevant action to get money or things stolen, or what do you do?
You plead them just like Elliot Spitzer did in the Grasso case. You plead 728.1 and 728.2, and then if you have a case under 728.2, you can pursue that in the same action. You can pursue a 719 action against directors if they haven't done their oversight. You can, through that, there's a knowledge element there. If you want to recover from an officer who has received an improper distribution, you've got to show that he received it with knowledge of facts indicating that it was not authorized by the statute. Knowledge is all over the statute, and that's what Grasso said, is knowledge of unlawfulness is the thing that protects the officer of a not-for-profit corporation who acts without knowledge of unlawfulness from being open to unended or open-ended liability.
So, counsel, if the term account for in 720A1 meant provide an accounting, isn't that different from account for?
It wouldn't really matter because...
No, but you're saying explain. So explain to me is provide an accounting. You provide an accounting, you show I spent the money for this and for this and for this. But when you account for something, doesn't that mean that you own up and take responsibility or have to...
If you look at Noah Webster in the first dictionary, which was 1828, you will not see that in that word.
Are we not in 1828?
Where, if you look at the one now...
how many, 200 years later?
Yes, ma'am. Yes, and it's still the same. It hasn't changed. The fact is that an accounting, even an equitable accounting, has two steps. You provide a report or information, and then if the court has ordered an accounting before a referee and it comes back, then the next step is whether anything is owed. If the legislature had wanted to say that here, they could have, they would have. In 715, they said to account for and pay. So in the same statute, when they want to say account and pay, they said account and pay. They knew how to say it. They didn't say it in 720.
So that I understand you, counsel, so it makes sense to me. Let's accept for purposes of our argument that the jury verdict finding fault as to his fiduciary duties under the non-for-profit law here. Find fault, that he breached those duties and that he was not entitled to the $4.5 million in a general way. What do you believe the judgment should have done here?
I think
what should Mr. LaPierre, in response to that, what the penalty, what the remedy?
At the end of the presentation of the Attorney General's case in chief, I stood up and said, Judge, you need to dismiss this now, the second cause of action, because Mr. LaPierre has resigned, which moots the question of whether he should be removed, and he has accounted for his official conduct. And that's all that they're entitled to under 720A1. The judge denied that motion. We went forward. I raised it again and again and again, kind of to the point of annoyance. But ultimately, he asked for instructions to the jury. I said, please instruct the jury that in order to obtain a judgment for monetary relief, you must show the following elements, and one of them was an unlawful transfer where he knew of its unlawfulness, and the judge refused to do it. And that's the error.
May I just ask you, so there was part of the relief that was given that prevents your client from serving as an officer or a director of the NRA for 10 years. There's some a little bit of discussion about whether or not the court had the right to do that, and whether there was an issue about was he ever a director? Is there proof that he was ever a director?
No, there's not. He was an officer, and by reason of being an officer under the bylaws, he was an ex officio member of the board of directors in certain committees. But under the bylaws, there are 76 directors with right to vote. He had no right to vote, no right to attend meetings without permission. He was not a director. So 706 is out of it. 714 is for officer, but even if the court had the power to bar him, which it didn't, the power was to bar re-election or reappointment to that position previously held. This bar goes beyond it. It goes to any director position, not only for the NRA, but for any entity under its direct control. And as we say in our brief, there are 8 entities listed in their 990 as being under their direct control, most of whom, none of which are organized here, some of which aren't even not-for-profit corporations. So what the Attorney General of the state of New York and a New York judge are doing, telling him he can't work for someone in Nevada, for a nonprofit entity in Nevada, because it has a relationship to the NRA, it tips over into the constitutional issue, which is how can that be permitted by the Constitution of the United States?
Counsel can't work? You said he can't work for an entity?
Under this bar, he cannot work in a fiduciary position as a director or officer for any entity under the NRA's direct control. That would include the NRA Foundation in D.C., which is under the jurisdiction of the D.C. Attorney General. They are operating under a settlement agreement down there, so this is reaching out into another jurisdiction.
Thank you, counsel.
Thank you very much.
Thank you both. People v. Jason Perez.
Good afternoon, Your Honors. May it please the court, my name is Stephen Burko, and I represent appellant Jason Perez on behalf of the Legal Aid Society. Your Honors, the verdict in this circumstantial evidence case was against the weight of the evidence because the inference of guilt is not the only one that can be fairly and reasonably drawn from the facts, and the evidence does not exclude a hypothesis of innocence beyond a reasonable doubt.
Going into the closets with empty bags and coming out with full bags, that's a problem?
Well, Your Honor, we're not disputing that fact, but we are submitting that it was Mr. Perez's first day on the job, that he got through his cousin, George Washington, who acted in a sense as his benefactor. So it was natural for Mr. Perez to defer to Mr. Washington, who entered the closet with a key, didn't break into the closet in any way.
So in other words, your client, who was charged on the first day with removal, cleaning duties, thought it was appropriate to go into the victim's closet and help clean out his closet. Is that my understanding here?
Your Honor, naivete on behalf of my client does not necessarily equate. Pardon me?
Do we have that in the record? When you're saying naivete, how old was Mr. Perez?
I don't recall offhand how old.
So we don't know that he was naive, do we?
Well, we do know that his cousin got him the job.
Yeah, but that doesn't mean that's not necessarily good under the circumstances that are presented here. I mean, how did he leave with the items that they bagged? Didn't he use an exit that went straight to the street?
My understanding is that they took it to a storeroom and left it there for a bit and then went downstairs with it.
No. Didn't they go out the stairways? Didn't they take an exit that went directly to the street as opposed to the normal way that you travel in this building?
If I recall from the record, there was a step between that, but yes, and eventually they went down to the street.
And isn't there surveillance tape showing empty bags in, stuffed bags out?
Again, I would just repeat, Your Honor, that under the standard of law, it's not necessarily that the most reasonable hypothesis is the one that prevails. It just has to be a reasonable hypothesis, and we maintain that in light of the fact that it was Mr. Perez's first day on the job, and that his cousin had gotten him the job, he was beholden to him and just simply followed his orders.
The property in question amounted to $32,000 worth of Givenchy sweater, dress coat, Kenzo tracksuit, I don't know how you say this, Lanvin?
I'm not sure, Your Honor. We're not disputing the value
coat?
of the
Really?
merchandise that was.
I'm sorry, what did you say?
We're not disputing the value of the merchandise. What we are saying is that the people have not proved his intent beyond a reasonable doubt.
Thank you, counsel. You have time in rebuttal.
Thank you.
Good afternoon, Sarah Chalfont for the People. The surveillance video trial testimony, as well as the reasonable inferences that could be drawn from this evidence, provided ample support for the jury's verdict, which comported with the weight of the evidence. Defendant does not contest that he's captured on surveillance video entering the closet and exiting with stuffed duffel bags, and does not challenge the value of the items that are stolen, nor does he dispute that he did not have permission to be in this closet. Instead, defendant's only claim is that the evidence did not support the conclusion that he possessed the requisite intent to commit a larceny or burglary. However, to walk through the surveillance just briefly, the video surveillance begins with defendant's cousin repeatedly walking up and down the hallway where this closet is located, at one point taking out a key and struggling to open the closet door, leaving a duffel bag in the closet before going back seemingly to prep the closet for coming back with defendant later.
By the way, there was evidence in the record that the cousin didn't have permission to use the key. The key was kept in the manager's office for emergencies, et cetera.
Correct. There was testimony both from the head of security as well as the construction supervisor in this case that defendant nor his cousin had permission to be in this closet, that construction on this closet had been finished for some time. The video surveillance then goes on to show defendant and his cousin repeatedly, twice at least, going into the closet with once with defendant wearing his personal backpack, which appears at least to be empty when he enters and is stuffed when he leaves, and then coming back with a second time with a different duffel bag, which is empty when they enter, again, appears to be stuffed when they leave, before going back and seeming to sort of rearrange the items into other bags and then leaving through an exit down to the street. This is an exit that was only for emergencies, that doesn't have surveillance. After defendant and his co-defendant had both at least entered the building through the normal entrance, which would be the elevator. They instead avoid the elevator and surveillance by going down this separate exit. If there's no further questions, we rely on our...
Do you think that defendant, because it was his first day on the job and he was naive, didn't know what he was doing?
There was ample testimony from the construction supervisor in this case that his responsibilities had been explained, that they had provided, that his responsibility was to remove construction-related debris from this site where construction was going on, that his responsibilities would never have involved using his personal backpack to remove clothing items from a closet, that it really would have been limited to garbage, construction debris. So it's not reasonable, and there was no reason for the jury to infer that he was just naive in doing this at the direction of his cousin. It was much more reasonable in this case for them to conclude that defendant had the intent to remove items permanently.
Cousin pled guilty to burglary in the third and was sentenced to probation, right?
Yes.
And here the defendant went to trial and got, how long, 2 to 4?
2 to 4.
Concurrent?
Yes. Thank you.
Thank you, counsel.
No rebuttal, Your Honor.
Very well. Thank you both, counsel. O'Sullivan v. American Golf Corporation.
Good afternoon, Your Honors. May it please the court, Julia Audibert with Wilson Elser on behalf of American Golf Corporation. The order denying American Golf's motion for summary judgment was improperly denied and should be reversed in following with the decisions of this court. The plaintiff has not identified any defect. The plaintiff rather testified that
Wait a second, I don't think that's true. I thought the plaintiff showed by testimony and pictures that there were cobblestones that were in a pretty crappy condition in the parking lot owned by American Golf, which is where they were dropped off when they got to the event that they were attending at the location at the golf course. So I don't think that they didn't identify it. That's what they claimed. His foot got caught in between the gaps between the cobblestones.
And I'll start with first that the photograph in the record, it was attached to Omega's motion, and the plaintiffs in opposition failed to raise a trial issue of fact because the plaintiff's affirmation and their opinions as to the improper spacing of the cobblestones is a technical question. American Golf has an expert that opines to the fact upon personal inspection that the cobblestones were uniform and an ordinary
Does that
walkway.
meet your prima facie, though, if it's 5 years after the accident?
I'm sorry?
Does that help meet your prima facie on summary judgment if the expert observed the cobblestones 5 years after the accident?
There's testimony in the record that there was no changes to the cobblestones in those years up until the the opinion of the expert. And in conjunction with the expert, American Golf has shown through the testimony in the record that the cobblestones were uniform, not slippery, not broken, no missing or loose stones.
But I'm sorry, I didn't mean to cut you off. I think the fundamental question here is that the plaintiff alighted from the bus and got his foot wedged in the gap between two cobblestones. Bear with me. It's a slip in the wedge. And what's clear from your expert opinion is he doesn't discuss the gaps. He discusses the cobblestones. Yes, no one's arguing that the cobblestones are defective. No one's arguing that there's a defect in perhaps how they were placed, whether it's uniform or irregular. The focus is those gaps. And your expert was utterly silent about those gaps.
The expert does say that there's no spaces between the cobblestones that could be considered dangerous.
Where's the space issue? I'm looking at the affidavit. So where does it say anything about space between the cobblestones? Because I don't see it. I'm looking particularly at paragraph 9 found in the record of 584.
Nor does he refer to any kind of standard, industry standard as to how they should be installed and placed, et cetera, to suggest that this was normal and not a defect.
If I can respond please to the space, in paragraph 11, second sentence, the expert says there is no space between cobblestones that could be considered dangerous and or defective. And then to respond to your question, which I'm sorry, could you repeat it? I'm
sorry.
No, you're fine.
The existence of standards.
Oh, thank you.
Was
Yes.
invoked by
Yes. So the expert states that there's no standards that apply to these cobblestones, and to the extent that the plaintiff argues under the Giraldo case, that case deals with New York City sidewalks and properties that abut those sidewalks being responsible for maintaining the sidewalks and those pavers. Those codes are not applicable to the cobblestones of this private driveway.
Thank you, Counsel.
Have I answered all questions? Okay.
You have time in rebuttal.
Thank you, Your Honor.
The bus company just has a Me Too argument. So you're the plaintiff, are you not? Yes. Please, go ahead.
May it please the court, I'm Richard Duby, I represent the respondent. I'm asking that this court affirm the lower court's denial of summary judgment. Her opening statement, with all respect, she said there's no finding that the plaintiff identified where he fell. Judge Goldman expressly said in her decision that plaintiff's testimony said his left foot got wedged between the two cobblestones was sufficient to identify the cause of the fall. Okay, for Your Honor's question. With respect to the experts, this is not a defective cobblestone case. This is not a slip and fall case. The gap between the stones is the tripping hazard. And the defendants failed in their motion for summary judgment by their own papers. They didn't show that there were no material questions. They didn't dispute the facts that happened. My client, while merely alighting, is a 27-year-old strong young guy for a golf outing, steps off the bus, his foot gets wedged, he loses his balance, and his ankle snaps, and he rips his tendons.
So let's talk about paragraph 11 in the expert's affidavit, where it says, no missing stones were observed in the areas identified in the incident area by Mr. O'Sullivan. There was no space between cobblestones that could be considered dangerous and or defective. Does his finding, his opinion, 5 years post-accident, that there was no space between the cobblestones sufficient to allay whatever concerns there
With
are?
all respect, Judge, the expert was a woman. Her expert testimony was completely disregarded. Not only was it 5 years later, but there were no measurements.
Who was a woman and who was disregarded?
The expert, Kafala, I forget her first name, Ms. Kafala was the expert. Her affidavit, she didn't measure the stones. She didn't measure the space. She merely opined it's not a tripping hazard. And the judge said, there's no regulations, there's no building code standards, you didn't measure the stones, you didn't measure the gaps. The gap itself is the tripping hazard. So the court didn't even give any credence to the expert.
But I guess even if the court had given some credence to the expert, the plaintiff still raised issues of fact because he said 5 years ago, 5 years before the expert came.
The whole case has questions of fact. Premises liability, the property owner has to keep the property in a reasonably safe condition. There's questions of fact whether or not they kept it in the reasonably safe condition. And I don't know if the court picked up, I put it in my papers, but they argued in their motion for summary judgment, my guy couldn't identify it, and, 1 second. My guy couldn't identify the defect, and they had no notice. Now, on their appeal, they say that the cobblestones were open and obvious, and they were not inherently dangerous, which they didn't even preserve for appeal. So they kind of did a 180 on us. But my opposition papers, all we did was identify questions of fact to support the denial of their summary judgment. But the court never even reached my papers because their own papers failed. So I would ask that this court affirm the decision of the lower court.
Thank you, counsel. Counsel, you're here for Omega? You just want to make sure that you're not brought into the case somehow?
You want to be brought back, right?
Good afternoon.
Have you heard anything that has threatened your status as being out of the case?
Negative, Your Honor.
Okay. Anything else you want to tell us?
Did you make your appearance first?
I'm sorry, Nuo Jang, Capehart, and Scatcherd for Omega in this matter. Omega does not take a position in this appeal. Thank you, Your Honors.
All right, counsel, you're up.
Thank you, Your Honor. I'll start first with the argument that the cobblestones being not inherently dangerous and open and obvious, not being preserved for appeal. In our papers below, we did argue that they were open and obvious, to which the plaintiff responded. If you look to the record at, I will find the page, but in our briefs, we explained that that was argued and the plaintiff responded to it.
That. Yeah.
Moving on to the second point that I wanted to make, which is the question here is not whether the plaintiff's foot can be caught between the stones. The question is whether the stones are open and obvious and readily observable to anyone making reasonable use of their senses. In Zhao, sorry?
Counsel, I don't know that that's the question. The question is whether whether paragraph 11 has a conclusion that's not supported by any measurements or industry standard. It simply says no space.
If I may, if I may, with the court being dissatisfied with the expert affidavit, in Zhao versus Brookfield Properties, this court, as Judge Katnick may recall being on that panel, this court, based on the photograph provided by the defendants, held that the defendants met their burden, that a cobblestone, and if I may just finish my thought, Your Honor, I see my time is up. The cobblestone walkway, ordinary cobblestone walkway that is open, obvious, and safe to navigate, as 30 others did, alighting from the bus, is not an actionable defect. And that case controls here. This was an open, obvious, readily observable walkway. And unless there are any other questions, I will leave my arguments to my papers.
Thank you very much, counsel. Thank you all.
Your Honors.
Valencia v. Saul Goldman Investments, LLC, et al.
Sure.
Please.
Your Honor, Tom O'Connor for the appellant. As the court is aware, there are 3 legal issues in this case, and that's all there are, and they are each legal issues. The first issue, and I'll deal with them in turn, is the first one has to do with the contractual liability claims that are assessed against Coney by the defendants, because I think that frames the issue for the court. What they brought in is they brought in a contract.
So bring the microphone a little closer.
Sure.
Thank you.
They brought in an assumption agreement, which they say is evidence that somehow Coney was involved in some sort of contractual agreement with any of the defendants in this case. That agreement, Your Honor, has a date that says it's not effective until 2017. There's also no evidence in this case from a single witness, including the president of City Elevator, that that contract was ever entered into by anyone.
The person who responded after the accident, though, was a Cone employee, was it not?
It was, Your Honor, and that gets to the second point, which is that there's no contract. And the second point is, who is that employee and what is his role in this case? With respect to Coney has no contract with anyone here. It's borrowed labor. This gets into the borrowed servant doctrine. In this instance, Coney is the general employer, and they are special employee, though, with City Elevator. City Elevator is the ones that designed this contract, this elevator system. It's the one that installed this elevator system. The property.
But you took over to start servicing the elevator, and the allegation here is not that necessarily they installed it wrong, but it wasn't serviced properly. It wasn't because there had been a problem once before, I think, in this particular elevator, and then there was a problem again. So it was the servicing issue, and that was what you were now doing.
That's, Your Honor, as the general employer, obviously we're involved. We're Coney. The question is, for this particular instance, in the installation and in the servicing, are we special employees of City Elevator because they had the contract? In this instance, we are special employees. If you look at the direct testimony of Mr. Hellman, the president of City Elevator, he says, we have subcontracted our labor through Coney to fulfill our obligations for the installation and the warranty maintenance agreement.
So what specificity do we have with respect to who was a special employee or not a special employee, how long they worked, what they were paid, what their names are? Where's the information? How can a court determine whether someone should be accorded special employee status in the absence of that?
Your Honor, that's a perfect question for this, especially in this instance. We don't have any contracts with any of the defendants in this case. We don't have a contract with the GC. We don't have a contract with the leaseholder. We don't have a contract with City Elevator with respect to this. What we have is an arrangement where City Elevator kept this contract. This is one of the excluded contracts under what's called the APA agreement. As excluded, City Elevator went to us, and the testimony in this case is unequivocal. The testimony of City Elevator's president is that I subcontracted my labor from Coney to fulfill my contractual agreement for the installation and my contractual agreement for the maintenance period. That testimony sets up that they borrowed labor from Coney to fulfill their obligations under this. If you look at City Elevator's supervisor on this job, his foreman, the one that supervised this job from the beginning to the end, he did change employment from City Elevator to Coney. But when asked on this job, which was excluded, who did I work for? They were paid by Coney, but the supervision of this job, the control of this job, was City Elevator. And that's Chris Mertens, Your Honor. So with respect to that, you can borrow labor to complete your jobs. And that's what they did in this instance. And there is no contract agreement. There is no indication that Coney ever entered any agreement to take over responsibility.
There's records, aren't there?
Your Honor, that's absolutely right.
We don't have any of those, do we?
Your Honor, in a borrowed servant environment, I'm not denying that these employees that they're talking about wore Coney uniforms that had Coney attachment. That's not the issue. The issue is,
nor do you challenge that there were Coney work ticket.
I don't challenge that at all, Your Honor. No.
Your logo on top, making clear this was your work, and that you were responding to the complaint in March and ultimately to the situation in May with the drop.
Your Honor, that's absolutely right. And when you determine these analysis, under this type of analysis, you have to look at who's in control of the job site, who's supervising the job site, who ultimately is responsible for the job site. And
Mr.
this is-
Hellman made clear in his affidavit in support, 1681 to whenever he finished his affidavit, that it was your guy.
Your Honor, and this is where it gets in. This is the legal error, if I may answer the question. I see my time is up. This is where I'm going to answer the question for the court. The Hellman affidavit is not probative evidence. It is a feigned issue of fact.
You submitted it in support of your motion, so didn't you adopt it as accurate?
I did not adopt the Hellman affidavit, Your Honor. That came in opposition to my briefing.
Am I wrong? Did you not submit his testimony?
His testimony, Your Honor, his testimony is contradictory to the Hellman affidavit. The Hellman affidavit completely contradicts what he testified to. That's why it's a feigned issue of law. That's why it has no probative value. And that's why the only thing that they've brought in opposition to the actual testimony of their president is the fact that they brought in an affidavit. But you can't bring in an affidavit that contradicts the sworn testimony.
Thank you, counsel. You'll have time in rebuttal.
Thank you, Your Honor.
May it please the court, Scott Taylor for Respondent City Elevator, CEMD.
Sorry, who are you here for?
I'm sorry, Your Honors. City Elevator, CEMD.
CMD, okay.
As this court noted, all we have in this case is the appellant asking this court to reverse based on uncorroborated testimony of its own vice president, which is obviously self-serving, but more importantly, is not supported by any other evidence. All the evidence in the case is the work tickets of Coney. Coney admits that it paid these employees. Hellman's unequivocal. The reason why his affidavit was submitted is because in 2 days of testimony, he was never specifically asked.
So did it contradict or did it just add some information that may not have been presented during his deposition or discussed? Is that what your claim is?
Precisely, Judge. I mean, he was never asked those questions, so he never gave that direct testimony, so he couldn't submit that testimony as supportive. So we put in his affidavit, and his affidavit is unequivocal. I mean, he says it was supervised, directed, controlled, 6-7 months, and that's supported again by the work tickets. This is a company that was winding down its operations, and these guys were wearing Coney uniforms. I mean, there's just nothing in the record other than this uncorroborated testimony of Tomasino, who's the vice president of Coney. That's all we have. And I admit that's enough to create a question of fact, which is why we never moved for summary judgment ourselves. I mean, it would have just been the battle of the two affidavits, but it's certainly not sufficient for summary judgment.
Did you address the issue of indemnification?
Well, we didn't address that, Judge. I mean,
That's not your issue.
It's not, it's not even in our brief.
Okay.
We'll hear about that from the owner defendants.
Yeah.
Thank you.
Thank you, Your Honors.
Good afternoon, Your Honors. May it please the court. My name is Michael Warricha.
Could you put that mic up a little bit?
For Sacco and Felix, for the plaintiff appellant, Mr. Valencia. So,
I'm sorry, you're not for, what about the owner defendants? You're not that's you. Okay, why don't we take him first, and we'll take the plaintiffs. Thank you, counsel.
All right, thank you.
Appreciate it. So you heard the indemnification question. If there was no contract with Kone, between your clients and Kone, how is there contractual indemnification?
Your Honors, Artie Venti for the owner entities, Sol Goldman. So the asset purchase agreement purchased all of the contracts of City Elevator. There was an indemnification provision in the City Elevator contract with Gotham, the general contractor, that included the ownership entities.
I thought that this particular contract was not referred to in that purchase. I mean, it wasn't specifically assigned, this particular subcontract.
It was not in the included contracts. Right. It was not in the excluded contracts.
So where is it?
So it was all encompassing. It was part of the entire assets. I would contend that it was included. Based upon the further agreements, Kone renewed the contract back in September of 2018 for the maintenance. It provided the employees, it assumed all roles that City Elevator did after its assets purchase, and we include that the indemnification was also included in that asset.
So, we have a problem with retroactivity, right? How do you justify that in the absence of language that says this indemnification goes backwards to when the work first began, or when the working relationship between us began?
Well, we're stating that the contract was purchased by Coney. Coney purchased the contract and all the liabilities within it, including the indemnification provisions.
So if it wasn't specifically excluded, it was included, even if it wasn't listed as included.
It wasn't listed as included, it wasn't listed as excluded. So there is an issue as to that, and that must be determined by the finder of fact.
Thank you, Counsel.
Thank you.
Good afternoon, Your Honor. Once again, I'm Michael Warcher for Sacco and Felix. May it please the court. So I would just like to add, all the testimony points to the fact that Cone was responsible for the maintenance of the elevator. This type of accident doesn't happen without negligence on the part of somebody, and it's alleged that this is Cone. The elevator dropped 4 floors. We also submit that the defendant had notice through 5 prior complaints, there's work tickets. There's plenty in the record to show that they were on notice of that this elevator had something wrong with it.
You don't need the exact same condition to be on notice generally with this particular situation. Right?
There was one, I believe, one prior
in
condition
March.
where the elevator did drop, and there's subsequent numerous complaints with the elevator. If you look at the work tickets that were submitted, they're bare boned. It doesn't say what the problem was. It doesn't say what the repair was. It doesn't specify what, if anything, they did. They just came out there, and it's a blank ticket pretty much. Also, in terms of the fact of their expert witness, it's based on no firsthand knowledge. He didn't go out and to inspect the elevator. All the testimony from any of the witnesses on behalf of Cone is that they didn't go out and inspect the elevator as well. They had no knowledge about what repairs or what was done at the time. So there's no firsthand knowledge by their expert of anything pretty much. So and we also will rely on the theory of res ipsa loquitur, where all those three criteria are met. So based on that, we feel that the lower court was correct in their decision, and this appeal should be denied.
Counsel, is there any corroboration or explanation of the argument that this was a machine brake stop?
What's up? I didn't hear the last part. The machine.
Machine brake stop, motor brake stop. Excuse me.
Well, I do see that was like probably in 2 of the documents there was I think that was listed there, but again, it doesn't really address how it was fixed or what caused the issue, and based on the 8 months prior, I mean there was 5 complaints. There's nothing in the record it appears that it's like a recurring condition, and I think and in those records they're not addressing that, like what's going on with the elevator. Why do they have to come out 5 times in the prior 8 months? And still, still a problem with the elevators.
Thank you, Counsel.
Thank you, Your Honor.
Good afternoon, Your Honors. Travis Wong for the plaintiff Diaz. I just want to address 2 arguments very quickly, and specifically with regards to the notice. Plaintiff Diaz was involved in a similar accident on March 10th. Defendant's experts say that didn't happen. That's a question of fact, or at least raises a question of credibility. And that can't be disregarded. And then just with respect to the special employee argument, on page 945 of the record, it basically describes how Kone would take care of the elevator. They would receive a call, the Kone employees would go, the mechanics would perform the repairs or maintenance. So there's no demonstration or no evidence supporting the conclusion that Kone actually relinquished control over their employees. So how can they just be a general employee if they haven't relinquished their control? They haven't demonstrated that. They haven't gone far enough. So therefore, their motion for summary judgment should be denied. Thank you.
Thank you, counsel.
Your Honor, briefly, with respect first to City Elevator's argument that there is no evidence in this case, and he reverts back to Tomasino, who went back with Tomasino, and with respect to his testimony. That's the testimony of every principal in this case, whether it's the principal of Extel, whether it's the principal of City Elevator, whether it's the principal of the GC, they have all testified the same. They had no dealings with Kone on this construction site. They had no dealings during this entire project with any Kone supervisor. These were, all of them testified the same way. Extel, and then the supervisor on the floor testified the same way. This elevator was installed and it was maintained by City Elevator, who supervised the work on the job. Second thing is the APA specifically says if the contract isn't mentioned, it's excluded. And City Elevator testified also that this was one of the excluded contracts. That's what their president testified to at his deposition. So the fact is that somehow we've incorporated this back into the APA because it isn't specifically stated as excluded is not right. Everyone agrees, and there's uncontested evidence that this was an excluded contract and that the $6 million that this contract was cost to install was paid to City Elevator. There was not a single invoice from Kone to any of the defendants. There's no evidence in this case at all that any Kone supervisor ever went out to that work site. This was borrowed labor, and City Elevator supervised the entire installation and the maintenance contract. With respect to the last argument, with respect to notice, the only opposition to our motion that there is no evidence that this had a defect in its operation is a lawyer's affidavit. That cannot raise a presumption of fact.
Well, a lawyer's affidavit could, of course, put in front of the court documentary evidence.
It can put in front of a court documentary evidence, but this one, Your Honor, goes to interpret maintenance and engineering documents, which a lawyer cannot do and which the court cannot do. This court has said you need expert evidence when it's outside the ken of a juror. Here you've got maintenance tickets, and there is no one in opposition that could interpret these documents from a technical or engineering perspective. It cannot raise a question of fact, as the court found.
Take the point, counsel. Thank you all very much. Suazo v. 501 Madison Sutton. Please.
May it please the court, Jessica Smith of Morrow Lilling Party for Superior. So I'd like to start with the issue of the retroactive intent of the Atlantic contract. Essentially, yes, the contract was signed after the accident, but it's our position that there is indicia of
Can it be retroactive just if Mr. McGuigan says so?
No, actually, I'd like to point to the phrasing in the contract that is written to apply to any job in all locations. There's no time limitation on that, and that could have easily been accomplished had the parties intended that to be the case. I'd also point to you that after the accident...
Don't they have to, if they're going to consider something retroactively, doesn't there have to be something specific? That's not presume that things are retroactive when you sign contracts.
So it's explicit words or necessary implication. So the necessary implication, I would say here, by any and all jobs is that they intend to include any and all jobs. I would also add that there's no actual explicit evidence that there are going to be future jobs in this case. The work was already fully complete at the time that they executed this contract. And I'll add additionally that there was a certificate of insurance that was submitted by Atlantic to Superior after the accident, and the provisions of the insurance in that actually comply with the terms of the contract, which also is indicia of their intent to follow through on this contract post-accident. Additionally, I would like to point this court to Podolsky, which is addressed in the brief. They actually deal with the issue of the absence of a time limitation on an indemnity clause entered into after the accident. So I would point that that is actually directly on point here. But Essentially, yes, we have the affidavit, but I would say that at the very least, there's enough ambiguity in the contract between the date it was signed and the intention that it includes any and all jobs.
Counsel,
Plus,
I don't understand what you're saying about the certificate of insurance. Are you saying that a certificate of insurance was obtained which provide retroactive insurance coverage?
no, so the contract actually, well, I shouldn't say no. There was a certificate of insurance that was dated after the accident and submitted. The contract
For coverage going forward, I assume.
Well, no, I mean, it has the dates of coverage. This accident would be within the dates of coverage. So it didn't change the insurance coverage. My point is, pursuant to the contract, they were required to submit a certificate of insurance with certain levels of insurance, and that they actually did after the accident. Once the job was completed, there would be no reason for them to do so unless they were entering into this contract with retroactive intent. That's my point to that. And if with my, so based upon that alone, I think there would be enough ambiguity to even consider the affidavit. But I'd like to move on to the other issues against the GC and Madison here. So they failed to prove that they were free from negligence, which is our position. It impacts both the common law indemnity, of course, and also the contractual indemnity orders that they have against our client. So essentially, they had to prove.
Let's talk about the contractual indemnity first. I mean, I don't really understand the argument that the plaintiff's accident did not arise from Superior's work.
Okay.
You try to sell me on that argument, because I didn't find your brief to be particularly persuasive on that point.
Sure. So essentially the idea, our argument is that we didn't supply the ladder, and that's really the ladder is the impetus for.
But he was doing spackling, and your contract was for drywall, which included spackling and taping the drywall, right? And that's what he was doing.
Yes, and I think our stronger argument is the negligence piece, if I can be completely honest with you. And so essentially they have to prove both here. Not only just means and methods, they also have to prove the defective condition theory here, because we have the equipment. It's defective equipment, especially the GC. They had control over the site and were.
So the existence of this defective ladder, regardless of everyone pointing fingers about it, that existence on the place this whole time is a defective condition that doesn't get them off the hook.
Yeah, it doesn't get out. Exactly it. It's a defective condition. I'd point this case to Herrero, and there's
the ladder is deemed a defective condition in this circumstance.
Yeah, so essentially, well, plaintiff already has summary judgment based upon the defective ladder, and if you look at the photos in the record, you can actually see the hint. So it's not just a defective ladder, it's visually, I don't want to say obvious, but visually apparent that they can see it on their walkthrough. So I'll just address everything else on the rebuttal if there's no
Thank you,
questions.
counsel.
Thank you.
Good afternoon, Your Honors. May it please the Court, Ryan Orich, Gallup, Tucci, Clark, LLP, for Respondent 51 Madison Sutton, LLC, 51 Madison Avenue, LLC, and GC Contractors. The accident, as we explained in our briefs, arose solely from the means and methods of the work. Plaintiff only injured himself through that performance of the work and the equipment used for that work. He fell off a ladder that shook, causing the accident. And since that accident occurred, due to the way or manner the project's equipment was used with the possible defect in the equipment, only the means and method analysis applies.
But isn't the ladder had an obvious defect? The hinges were off, and doesn't the GC have the authority to stop any work based on a dangerous condition?
Well, 501 Madison and GC Contractors, 501 Madison were the owners only, and GC Contractors did not give plaintiff any instructions regarding how to perform his work, did not supply any ladders, tools, materials, did not supervise Atlantic or Superior workers. We find instructive.
Are you answering her question?
Well, we find instructive the Siegel v. Delta Airlines case, and this court dismissed the common law negligence and labor law.
Counsel, are you answering her question?
Yes, that liability falls on Superior. And that is seen through the contract that
The GC doesn't have authority to stop work if they see an unsafe condition?
even if there is, so I understand your question, and we find it to be in means and method analysis, but even assuming this is not means and methods, if it is a dangerous condition to that contractual indemnity point, if it is a dangerous condition, we cannot be 100% liable for that. Superior expressly agreed to indemnify the defendants for all claims arising out of the work to perform for GC contractors, and that's to say that the agreement contemplated full indemnity for the defendants from Superior. Superior's hiring of Atlantic to help fulfill its obligations under the agreement falls within that. Atlantic performed the work in conformity with that purchase order, and in accordance with the requirements and accepted contract benefits. Superior cannot now assert that the accident did not arise out of Superior's work for the project. Further, plaintiff's own negligence regarding how he performed his work by intentionally climbing a ladder that he knew was defective and shaky is imputed.
I'm sorry.
Good.
There was an earlier decision which we affirmed the plaintiff getting summary judgment on 240. So the possibility of comparative in the context of damages is absolutely irrelevant to your argument now. Am I correct?
Well, Your Honor, we believe that Superior's argument for conditional contractual indemnity, that plaintiff's work was outside of the scope of the agreement, is inconsistent based on the unequivocal language of the agreement covering all work, including the work of Atlantic, which this fell under. If I could just go back to that Siegel case, we find that Siegel case to be the most instructive. There was, I see my time, but would I?
Finish the thought, counsel.
Yes. The ladder plaintiff used in Siegel was supplied by his employer. He only received his instructions from his employer. That is exactly what happened here, and that liability falls on Superior as they hired Atlantic.
But Superior denies it, the ladder being a Superior ladder.
There
was testimony or information on this record that Superior had a particular type of ladder that was colored a certain way, et cetera, et cetera.
And
right now, we have a record that's unclear where this ladder came from, but we know it was very defective explicitly based on the hinges, and that it was there, and that the plaintiff was told to use that ladder without anyone really knowing where the ladder came from and who really owned it.
Yes, Your Honor. I would just say to that there's nothing in the record that would show that it was the owner's ladder or the general contractor's ladder.
Thank you, counsel.
Thank you very much.
Good afternoon, William O'Connell, Goldberg Segala for third-party defendant, respondent, Atlantic Interiors. Your Honor, it's been a long day, so I'll get to it. In my view, the contract itself really answers all the questions about indemnification. It's very clear. It says in the first page of it, it's hereby made basically after the accident. So that invokes Workers' Comp Section 11, and that says there's going to be no indemnification in this case unless they meet this narrow exception where you have to show there was an agreement prior to the accident and that both parties intended that it should be enforced. And
Wait,
in this,
so big question.
Yeah.
Your friend talked about the certificate of insurance and
Right.
that it was in effect when the accident happened. And she points to that as indicia of an intent to provide indemnification. Could you address that?
yeah, she did say, to be fair, that it actually is dated after the accident. So it's our position. Obviously, we know what happens when these accidents occur, and there's talk between some of the parties. And they also had 100 jobs between them. And counsel said that there were no future jobs. That's not true on page.
Sorry, so the certificate of insurance was did not cover the accident.
It wasn't related to any specific site, and it could have related to all the jobs between these two parties. So, in other words, she's saying this certificate shows that there was an agreement here to indemnify, when in reality, it's kind of like a blank certificate of insurance. It does have the two clients' names, but it doesn't give a work site, and it's dated after the accident. So it's kind of like we're going to insure something that already occurred.
Thank you.
Okay, so that's basically our position. Also, common law indemnity, failure to procure, that's all out too, because there's no contract here and there's no grave injury. Thank you, Your Honor.
Thank you, counsel.
Just briefly, I'll start in response to GC and Madison. So our position is that they can't get an order of conditional indemnity here because they haven't proven their absence of fault. And additionally, all of the negligence allocation questions would still be open, right? So we don't know how much they'll be allocated in fault, and so that answers, that one point that he had raised. Also, I'd like to just point out that we also argue in our brief that Superior has no active fault, which essentially in the motion court's order, they said that Superior failed to supervise the Atlantic. So they had no duty to supervise Atlantic. They weren't actually on the site, so they didn't have control of the work area to inspect for defects. So I just want to make sure that that is an additional point of why the order of common law indemnity is improper, and why there should be an allocation of fault against GC and Superior potentially, if this case is tried. The certificate of insurance, yes, I did say it is dated after the accident, so I want to be very clear to not mislead the court. However, we're saying that shows the fact that they would have submitted it. It's right in the end of March, right before this agreement was signed. It's an indication of intent on the part of Atlantic to adhere to the terms of this agreement that they then enter into. That is the point of why I'm raising that here.
That's what we thought.
Okay.
That was the inference you wished us to draw.
Yeah. So if there's nothing else, I'll rest on my brief for everything else.
Thank you.
Thank you.
People v. Messias. Hold on one second, Council.
Nothing.
No. Please.
Good afternoon, Your Honors. May it please the court. My name is Kristen Fontaine, and I represent the defendant, Christopher Messias. We raised 5 points in our brief. I intend to start with point 5, which is the jury charge claim, and then continue to the multiplicity and duplicity and double jeopardy claims as time allows.
The people do consent to the dismissal of the 2 rape convictions for victim 2.
That is true, yes. And
we know
recognize that, yes. Thank you. So as to our point 5, the jury charge claim, the trial court blatantly omitted the forcible compulsion element from its charge on predatory sexual assault, specifically as it related to the aggregating factor of the rape in the first degree regarding the victim Catalina. And that, as a result, it requires reversal of the two charges of predatory sexual assault.
Counsel, go a little slower and microphone slightly closer. Thank you.
Thank you. The people's primary argument is that there's a threshold issue that the jury charge claim is not preserved for appeal. However, the people's preservation arguments are against the preservation statute as well as common sense. When you look at the criminal procedure law 470.05, it specifically claims that claims are preserved so long as they are expressly decided, the court expressly decides it. And here, the court did expressly decide the issue about whether the jury charge properly instructed the court as to the forcible compulsion element of rape 1.
Forcible compulsion was mentioned 3 times, correct?
Yes, you're correct.
So it was on the table.
It was on the table. However, forcible compulsion was only mentioned in relation to other charges. It was never mentioned in relation to the underlying aggregating factor of rape in the first degree as an underlying factor of predatory sexual assault. And I mean, just quickly getting to the merits of that, even though the court had specifically instructed the jury as to rape in the first degree and how that requires forcible compulsion, the court also specifically advised, and if we look to page 1651 of the record, the court specifically advised that although there may be similarities in certain testimony and certain elements of the charges, the jury must evaluate each charge separately and make sure that before coming to a verdict on each charge that they consider basically each element specifically and not relate to other elements or other charges on different charges because it would be improper. So in that respect, even though the jury did hear that rape in the first degree required forcible compulsion and other jury charges, and specifically as it related to predatory sexual assault and specifically as it related to the aggregating factor of rape in the first degree, the court did not include forcible compulsion. The jury's only reasonable conclusion was that for this specific instance, it doesn't require it, based on the court's instructions not to glean information based on and assume elements that the court does not specifically claim. And And the people also specifically argued that it shouldn't matter whether the jury did not instruct on the forcible compulsion element specifically here, because in the end, the jury did find the defendant guilty of rape in the first degree as to Catalina. However, as we also argue in our brief, the jury should have never reached deliberation on that issue anyway, because rape in the first degree as to Catalina was a inclusory concurrent count of predatory sexual assault, and so it only should have been given to the jury in the alternative and never should have been deliberated on. And on that point, the counts of rape in the first degree and criminal sexual assault as to Catalina should be dismissed as multiplicitous because they are completely consumed by the predatory sexual assault. And the people tried to distinguish People v. Lancaster. However, People v. Lancaster is the only case really on point here, and People v. Lancaster, the court determines that an aggregating factor, basically the underlying factor, not the primary factor for primary sexual assault, is still a lesser inclusory count of predatory sexual assault and must be dismissed as a lesser inclusory count if the jury convicts on predatory sexual assault. The same can be said for double jeopardy, and here we want to point the court specifically to statutory double jeopardy, CPL 40.20, which, as the court is aware, is much broader than constitutional double jeopardy. And here, for the same reasons as the multiplicitous argument, the convictions of rape in the first degree and criminal sexual act must be dismissed as a violation of double jeopardy because the defendant was already convicted of predatory sexual assault and already punished via those convictions for that specific same action. In the same vein, if we want to get to points 1 and 2 of our brief, that the people presented evidence of a second unindicted rape. Sorry, Your Honor, I see that my time is up.
We can talk about that on rebuttal, counsel.
Okay,
In this
sounds
end
good.
of all ruling. Thank you.
Thank you.
Good afternoon, Your Honors. Dana Poole on behalf of the people. Regarding the jury charge, that the defendant's complaint is actually unpreserved. He raised no objection to the charge that was given. He did not join it. The prosecutor did note to the judge that there was an issue with this. I think there was a little bit of them speaking past each other. And if this was of concern to the defense, they had the obligation to say something to the judge and to say, yes, we as the defense share this concern. So that is unpreserved. But even as a matter of, in the interest of justice, the correct charge regarding rape was given multiple times. And in giving the predatory sexual assault charge, the judge specifically referenced back to the previous rape definitions that she had given that did include the
Forcible compulsion, yeah.
the forcible compulsion. So overall, we know, especially because the jury did end up convicting the defendant of raping Catalina as well, there was no issue with that as an aggravating factor.
Now, on the Sandoval ruling, because I think your opponent's going to deal with it on rebuttal, did the court provide a tailored instruction about how the jury could consider the prior bad acts?
I believe that the court gave the general instruction. That was not an issue that was raised regarding how that was presented to the.
You were allowed to ask well, I'm sorry, not the jury, but about questioning, pardon me, about the questions that the defendant was allowed to be asked about prior convictions. It was limited to the names of the crimes and the dates committed?
The names of the crimes and the dates, yes. But the underlying facts were not admitted. And that they were felonies was not even brought out. And there was very limited testimony on that. And so the judge did do an appropriate balancing regarding that Sandoval issue.
With respect to victim one, the issue of duplicity, both the prosecutor and the defense really focused in the back seat of the car, not the front. So.
Yes,
You don't have any real concern there?
No, absolutely. The prosecutor specifically stated to the jury, there was this activity in the front seat, they got into the back seat, and there he committed the first crime, which was the the Criminal Sex Act, and then the second crime, which was the rape of Catalina. So there really was no confusion. And again, this is a space where the defendant was obligated to raise a concern if he had one. The fact that he didn't either shows that it was a very minimal error that had very little prejudice, or gamesmanship, and neither of those should result in a dismissal of that charge. And also that charge, the rape and the Criminal Sex Act, as they were charged, that conduct was charged as an aggravating factor. But that something was given as an aggravating factor to the primary charge of the rapes against Kayla does not require dismissal of those charges. They're aggravating factors, just as under subsection 3 of that same statute, an aggravating factor could be a prior conviction of a felony sex offense or a few others. Certainly, if that was used as an aggravating factor, that prior conviction would not get vacated under those conditions. So the aggravating factors are simply, they're bump ups. They are not lesser inclusories, as is the primary crime of the initial rapes of Kayla. And because those primary crimes were the same in both those two rape charges and the corresponding predatory sexual assault charges, that is why the people are consenting to the dismissal of the two rape charges, but neither of the charges that the conduct of which served as the aggravating factors. And unless there are any further questions, we will ask that you affirm the conviction. Thank you.
Thank you, counsel.
Just briefly, Your Honor, I do want to, before I get to the issue of the second unindicted rape, I do want to briefly touch upon something the people mentioned, which was the preservation of the jury charge claim. And it is true that the defendant did sit silent while the people raised the claim and the court addressed the claim. However, the defendant's objection at that point would have been completely futile, which is already built into the statute, that if objection is futile in light of the court's ruling, then no further objection is necessary. And if we look to the court's response to the people's very persistent when they were insisting that the jury charge was missing the forcible compulsion element, the court was very clearly frustrated with the prosecution for bringing this up and didn't really understand what the prosecution was even asking for, and was saying, I don't understand your objection. No, I'm done. We're finished. At that point, if the defendant had objected, I fear it would have frustrated the court even more and actually would not have resulted in anything different. And the court addressed the issue completely, and nothing would have changed had the defendant objected. And then as we get to the second unindicted rape, that one we do concede was unpreserved for appellate review. However, we do urge the court to reach it in the interest of justice, because this is a substantial issue where a defendant was convicted when the court, or when the people proffered evidence of two crimes under one single charge. And duplicitous counts are clearly prohibited by CPL 230. And as the people concede, the act in the front seat of the car did constitute a separate unindicted rape. They concede that in their brief. And it doesn't matter that the people focused very mainly on the backseat activity in their summations and their openings.
No, I mean, the defense is well focused on the backseat.
The defense as well focuses on the backseat, you're right, and that's why we recognize that it is an unpreserved error. However, the fact that the people recognize that it is sorry, can I finish that thought?
Please finish the thought.
That they do recognize that it is a separate unindicted rape, at that point raises a Molyneux issue, because at that point, even if the jury was clear that they were focusing only on the backseat activity, the people were allowed to proffer evidence of a prior bad act. They were allowed to proffer evidence that the defendant had previously raped the victim just seconds prior in the front seat, and that shouldn't have been allowed either. So we urge the court to reverse on all counts. Thank you, Your Honors.
Thank you both.